Lord,
For judgment pertaining to the terms of them, Agreement is 2025.
Mention.
Contentions raised by the writ petitioners are rejected. However, considering the facts and circumstances of the case, this court considered it necessary to mold the relief sought for, and therefore, the punishment which is imposed for 1 year stands modified till the date of delivery of the judgment. The impugned order of debarment for 1 year accordingly is suitably modified in terms of the above. Petitioner will now be able to appear for any such examination conducted by the APPSC subject to fulfillment of the provisions of the law. Writ petition is accordingly partly allowed, disposed of in terms of the above. Yes. Go ahead. Yes.
My lord, we have filed a one writ petition, my lord. I pray before your lordship to be listed for motion tomorrow, my lord.
When did you file it?
Yesterday, my lord.
Why?
Because,
What is the urgency?
my lord, urgency is that I have been transferred, my lord.
All right. That's tomorrow.
mail, please, my Lord. The case, my Lord, pending since 2021, my Lord, non-payment of family pension matter.
Oh. Let it be in January.
January, my Lord. They are already pending.
21 it is pending, you are
2021.
mentioning in 25. When was it last listed?
My Lord, about 1 year ago.
I got 1 year back. Now you want everything in December. Let it come in January, in the first week or second week. That's,
I beg to mention, lordship.
say 21st of January.
Then, my Lord, I mentioned later on, my Lord.
When do you want it?
My Lord, then I mentioned later on, my Lord.
Later on. All right. December is difficult because we have only effectively 1 week. That is next week. And all the dockets are filled up.
Are you, Lordship?
May I please, your lordship? Lordship, I beg to mention for listing, lordship. It was referred to the mediation, lordship, and mediation return, lordship, without settling the matter, lordship. So, my lord, December, lordship, I have some personal difficulty, lordship.
January.
Lordship, actually, lordship, I have own difficulty, lordship. If your lordship had the matter on in the month of December,
You have difficulty when?
lordship, I may join in new assignment, lordship.
Huh?
I'll,
You will join in new assignment.
lordship. December, lordship, in the next week, lordship.
Next week is not possible. We can give you a date, but don't complain if the matters are not called up.
Lordship. Any date, lordship?
11th.
Obliged, lordship.
Please, your lordship, with the consent of the other side, I beg to mention item number 23, your lordship. Lordship, today there is some difficulty, your lordship.
No, you are supposed to argue this matter. You are supposed to argue this matter. What difficulty have you got? What difficulty?
Personal.
Your personal difficulties you undertook to address the court on this matter. We are not giving you a journey. We'll pass out even if you are not there. We are not adjourning it. Yes.
Please, your lordship. With the consent of the other side, I beg to mention item number 6, your lordship. Mr. P.K. Tiwari, who is leading the respondents, your lordship, is unwell, your lordship. He is in the hospital.
This is something which both of you agreed to fix a date and now you are unwell.
He is in the hospital.
So what can be done?
Yes, your
Let the matter be listed in the month of February.
January 28th, Lordship, otherwise no inconvenient, Lordship.
28th?
So 28th of January, your Lordship.
28th of January.
20.
20.
20, Lord.
20 is not convenient.
Then 22nd, your Lordship.
It has to be 27th or
27.
29th.
27.
No issues, your lordship. 27th.
27th January.
Okay.
Lordship,
On the request made by the council appearing on behalf of Mr. P.K. Tiwari, senior council appearing by respondents 2 to 4 and 17, matters stands referred to be listed in the month of January, 27th of January. So the petitioner is also present, does not object to the prayer made. Yes,
may I please, Lordship? Lordship, I beg to mention for listing minutes on Monday. Transfer with, issue is transfer minutes.
motion admission.
Motion minutes. Lordship, I beg to mention item, with a concept from the other side. I beg to mention item number 25 from supplementary list, Your Lordship. Lordship, Council Mr. S. Botto has some difficulties today. He has to urgently leave for some other place, Your Lordship. The matter may be adjourned for the day, Your Lordship.
It will come in January. Item 25 on the request made by the council appearing to the petitioner, matter stands referred to be listed in the month of January on a date to be fixed by the registrar.
May I please, the Lordship? I would like to mention item number 12, Lordship. I have taken the concern of the other side. We need to file an affidavit, Lordship.
Lordship, I am for the petitioner.
Yes, any objection?
And
I
maybe a matter, the matter may be fixed, the date may be fixed, Your Lordship.
It is fixed today.
They have taken the consent.
You have agreed. What is the point in refixing a date? Matter stands deferred to be listed after 3 weeks, enabling the respondent council to file necessary affidavit. Prayer made is not objected to by the council for the writ petition.
May I please, Lordship? Also, I beg to mention for listing, my lord. It's an all pending 2015 writ petition, my lord.
What is
My lord, appointment of Gavura, my lord.
appointment of Gaon Board?
Gavura, my lord.
Right. 11th.
11, my lord. Oblige, my lord.
May I please, your lordship? My lord, one writ petition of 2019, my lord, pending for hearing matter, my lord.
Hearing matter.
My lord, yes, my lord, on the earlier occasion, when the matter was listed before this honorable court in the month of September, my lord, this honorable court, my lord, directed the registry to, my lord, to place the matter just immediately, my lord, after the Puja vacation. But
Then
till
what
the-
have you done? If it
Already, my lord,
listed?
pleadings exchange between the parties, my lord. Already, my lord, and service completed, my lord. So
What is
that
the matter about?
matter, my lord, earlier this writ petitioner before your lordship approves by filing a writ petition for suspension of from service, my
No,
lord.
Let
That has been
it
set
come
aside,
in January,
my lord.
22nd January,
Already possible, then.
not in December,
Well-
22nd January.
Fine, oblige.
May I please, I beg to mention item number 4, my lord.
Hmm.
In this case, I have to file rejoinder affidavit, my lord. Only
Item
one,
4 on the request made by the council for the petitioner stands referred for 4 weeks, list after 4 weeks on a date to be fixed by the registry.
Lordship, I'm requesting to mention an unlisted matter which was heard before the Honorable Court on 31st of October. This pertains to rejection of my candidature with IOCL. And this is the second round of litigation.
Why unlisted?
Because it did not come up.
So you make a mention, we'll get it listed.
If Milord's good,
11th December.
Milord's, if it would be on 9th or 8th. Because my senior is coming from Delhi, Milord's.
Your senior is coming from Delhi, ask him to adjust as per the court's calendar or have it in January. We can give you 22nd January or 20 January.
Can it be on Monday or Tuesday, Lordship?
It can't be on Monday and Tuesday. The dockets are filled up. We can give you Thursday or we can give you in January because the last week will be a miscellaneous day week. You're asking for hearing.
Yes.
To come back in January. 20 January.
My pleasure, Lordship. So I beg to mention for listing on phone matter, my lord. Can it be on Monday, my lord?
Monday.
Your Lordship. Your Lordship, I beg to mention a matter for listing. It's a 23 matter, Your Lordship. And previously, last week, we had mentioned it and it was listed for the 3rd of December.
Hmm.
However, it was,
Did not come.
Lordship, it did not come. Matter pertains,
Have it on 8th,
Lordship, 8th.
8th of December.
Lordship.
May please, your lordship. Lordship, I'm praying for listing on for admission, your lordship.
Admission matter. January.
Lordship,
What is the subject matter?
lordship matter pertain to promotion, lordship.
Promotion, we can have it in January. 21st of January.
May I please, Your Lordship? I beg to mention of a writ petition for today's list also as a production list. For production.
Why?
Because this matter pertains to your Lordship, SSC matter, Your Lordship.
What matter?
SSC, SS, Staff Selections Commission matter, Your Lordship. That the petitioners has recently rejected their OBC certificate.
Recently, how recently?
Yes, Lordship, on 30th, Your Lordship. 30th November, Your Lordship.
30th November. Unlisted, we can give you. It can come tomorrow if you want.
Yes, Lordship. Then tomorrow's your.
Oh, sorry, on Friday.
Can it be on tomorrow, Your Lordship? I think tomorrow is the Friday.
Huh? Tomorrow is Friday. Yes, tomorrow.
Yes, Lordship. Much obliged.
May I please, Your Lordship? My prayer is for listing a WBC Lordship. This matter regarding the petitioner service was released on in the year 22 Lordship. On all pleadings are completed Lordship.
January. 22nd January.
Lordship next week.
No.
Last day matter was listed, but the affidavit is not take. That's why it took time.
Whatever, now we come back in January. Termination matter.
Lordship.
It will take some time here. 22nd.
Yeah, please, Your Lordship. I would like to mention item number 2, Your Lordship. Due to some unforeseen circumstances, Your Lordship, the leading counsel, Mr. H. Umma, is unable to appear before this court today.
Where?
Sorry, sir.
Which matter?
Item number 2, Your Lordship.
Item 2.
Lordship, can it be adjourned for the day?
What is the matter about?
This is about, Your Lordship,
All right, you wait, let the matter be called up. Wait.
Lordship, I'm praying for listing of a matter in the admission. The matter last came up on 28/4/2025.
28?
4/2025.
Then January?
Lordship, can it be on 19th of December?
19th, it cannot be. We can have it on 27 January. Yes.
Wait,
Alright.
please, Your Lordship. My lord, motion matter, my lord. I'm praying for listing.
When did you file?
File, my lord, 18/11, my lord.
18/11 not listed.
My lord, listed on my lord 28, my lord. 28, my lord, we have, my lord, adjourned the matter.
Huh?
20, last listed on 28/11, my lord. This matter come, my lord. But my lord, my senior has some personal difficulty.
Oh, right. Then come back on 10th.
Oblige, my lord.
10th.
My lord.
Yeah, please, Lordship. Lordship, with the consent of the other side, Lordship, I beg to mention item number 3, Lordship. And adjourn the matter for the day, Lordship.
Wait for that. Wait for the matter to be called up.
Lordship.
Wait.
May I please, Your Lordship, I beg to mention listing of WBC for orders.
For orders.
Yeah. On 8/11. At 12.
On 12th.
May I please, Your Lordship, I beg to mention listing of a matter for admission next to candidate.
Okay, January?
Next week.
19 January?
My lord, just I have mentioned for listing on motion matter that is allowed on 8th, my lord, Monday. Similar matter, my lord, allowed on another matter tomorrow, my lord. I am also against
No, let it come on 8th. Tomorrow not possible.
similar matter that is fixed for tomorrow, my lord.
Maybe. Let it come on 8th.
Supplementary list for orders item 19.
But that content case, but first of all, my lord, you are facing a problem. Lordship, may kindly see, my lord, page 13, the order passed by the Honorable Court.
Page?
Page number 13.
13.
I would like to, my lord, straightway bring to your lordship's notice to page 14, the direction number 1. It's regarding, my lord, correction of date of birth in the service book. One says the petitioner within 10 days from today will file a fresh representation along with his proof of actual date of birth before the Director of Health Services. On receipt of such representation, the director shall within 4 weeks thereafter pass a speaking order regarding the correction of date of birth of the petitioner. My lord, in this regard, my lord, we have already submitted one instruction way back in 2023 that, my lord, the representation has not been submitted to us or we have not received it.
They have showed some document to.
They, lordship will see, my lord, why we are saying, my lord, even then, my lord, supposing it is misplaced in our department, at least a copy should be furnished to us along with those enclosures. Or, my lord, at least the enclosure should be given to us, my lord, to see, my lord, to verify.
That was handed over to the council
No.
yesterday or day
No,
before.
my lord. Along with those, my lord, date of birth certificate and all, that has not been given.
No, no, first you have to tell us whether it has been received or not received. There is a
No, not
confusion
received,
whether
but
it was.
The lordship will see, my lord, the honorable court earlier order dated, my lord,
They showed,
3/3/23.
no, they showed us the original to show that it contained a receipt stamp or something.
My lord, not received. Even today's instruction, my lord, I have got it. They are still saying that, my lord, we have not received it, but we'll pass the order. Furnish the documents to us, my lord. That's a.
Where is the counsel for petitioner? Who is the counsel for petitioner? Mr.
SP Chaudhary.
SP Chaudhary. Wait for some time. Let
My
the
lord.
matter be pulled up.
Tentative square admission item 1.
May I please, your lordship? Lordship, this matter pertains to lordship non-payment of salary, which has not been paid, lordship, since the date of my promotion, lordship, due to some technical irregularities, lordship. And lordship, subsequently, the lordship, that technical irregularities have been removed by the government, lordship, in the month of March. But till date, lordship, payment has not been made, lordship. In the meantime, lordship, I got retirement from service, lordship. Subsequently, I got a finance.
For this council, it's a council matter.
Council matter, lordship. Council has to pay, lordship.
Council
Government
has
has.
to clarify,
Who
lordship.
is the council?
Ex post facto approval has been given by the government law.
Who is the council?
My lord, I am appearing for the council.
What do you say?
My lord, we have filed our affidavit saying that the matter was in fact sent for the, to the respondent number 1, the commissioner secretary, for the approval. Otherwise, council has approved it, my lord.
You have approved it.
Yes.
Yes, lordship.
Approve this.
Lordship, this has been, we have filed our affidavit, lordship.
Yes,
In page 35, lordship.
yes.
Page may be wrong, lordship. Filed by the respondent number 6, lordship.
Yes, yes.
In paragraph 4, lordship, though it's a long para, lordship, but on yes, para number 2, lordship, further it is stated that the salary proposal through finance Assam portal so and so can be placed at administrative department, women and child development. Then the on receipt of these things, lordship, they have again moved. And on the next page, lordship, on receipt of the proposal from Principal Secretary NCHSC, Hilarious Department accorded ex post facto approval for filling up the post of supervisor in the year 2013 by letter number so and so dated 11/4/25 and thereafter issued instructions to the concerned treasury to release the first salary against Srimati so and so supervisor by number so and so dated 22/4/25, lordship.
So this was
Afforded, lordship.
ex post facto was accorded
Yes, lordship.
and treasury was directed.
Yes, lordship.
So what has happened now? Yes, madam.
My lord, they should get in that case because we don't have any objection. We have already said it, her appointment was.
What
as
is
per
your
law.
instruction?
Lordship, my learned friend is correct, lordship. Lordship, government has already accorded, lordship. Thereafter, lordship, that has to be paid by the council, lordship.
That
But-
has to be?
That has to be paid by the council. Council and the treasury. Council has to send a proposal, lordship, bill before the lordship treasury. And treasury has to pay, lordship. But that has not been done, lordship.
I'll take
Yes.
instruction on that, my lord.
You get it by today, 2 PM.
My lord.
Get it and we'll see what orders we can pass. 2 PM.
Obliged, lordship.
Item 2.
Yes, what happened here?
Your Lordship, this matter pertains to a service matter. Here, what has happened, Your Lordship? Petitioner who works as an assistant sub-inspector in the Assam Police Radio Organization. Lordship, at its headquarter office was removed from his service due to and was reinstated.
What are you challenging?
Your Lordship, we are challenging the requisite consequential service benefits and to treat his suspension as on duty. Your Lordship. And
Pleadings
as
are
in the-
complete. Pleadings are complete.
Your lordship, yes, the pleading.
Complete, my
Okay.
My lord can issue rule, my lord.
Third, can a council for parties issue rule matter be listed for hearing in the month of January?
That is free.
Yes, what happened here?
Yes, lordship. Yeah,
Who mentioned for, you mentioned? Why?
Lordship, my senior is not well, Lordship.
What is wrong with her?
Lordship, she is suffering from cough, Lordship.
What is to be done here?
otherwise, yeah, the issue is lordship, the dismissal from service in the Assam Rifles. Dismissal from service from Assam Rifles, lordship. So he was dismissed for lordship producing or placing lordship that false matriculation certificate at the time of his enrollment. Lordship. And lordship, the impugned order is at page.
If she's not here, then there's somebody else who can appear.
Lordship,
Standing council, CGCs, if you're not there, your colleagues should appear in the matter. Once the matters are listed, then you should adapt yourself to the list instead of trying to give your own calendar.
Otherwise, my simple prayer is that lordship, matter may be lordship remanded back to the authorities, lordship, for giving some lenient lordship punishment. The punishment is lordship, it's severe form. Lordship,
Where is the order of removal?
That is at page 20.
20.
He submitted fake documents, lordship, matriculation certificate at that time because of the poverty and penury. So, but he served for 10 years, almost 10 years without any break and blemish, lordship.
So how did the Assam Rifles come to know after 10 years?
Lordship, they used to make verification regularly in interval of time, lordship, regular interval, lordship. So they came to know for 10 years he served without any break and blemish. Lordship, this is the most.
If you have submitted false documents, then how can the punishment be lenient?
Lordship,
Rightly dismissed.
my prayer is, lordship, that till 10 years, lordship, he was not, lordship, even and during the period of 10 years, lordship, he acquired a matriculation certificate also. He passed also to open mode, lordship. And lordship, there is a judgment of this honorable court, lordship, taking lenient view, lordship. May I please that lordship was one of the division bench.
Why should there be a lenient view in case of?
Lordship, they may just since years discharge duties for 10 years, lordship, without any.
You have discharged duty by fabricating documents, false documents.
Actually, it was
your selection, your entry into the service itself is illegal. So, whatever services you have done it, because of you, somebody who otherwise would have been employed has been deprived.
At the time of submission, he was not aware that was the false and fabricated certificate.
He has not challenged all that.
Lordship.
What judgment? Let us see.
Lordship was the one of the. Instead, it may be converted to compulsory retirement also. Lordship. Dismissal because with your civil implications is also there. He is not getting any job in civil also, Lordship. And this has not only cut his lordship salary or the lordship livelihood, lordship, all the family members will be suffering, lordship. Considering that, lordship, the holistic view can be taken, lordship. Paragraph 9, lordship.
No, this is something different.
This was also, lordship, the same of CISF, lordship.
No, this is a case of second marriage.
Second marriage, lordship.
Not false documents.
There, but second marriage is also, lordship, the punishment is dismissal in terms of the statute, lordship. So, lordship, a holistic view was taken, lordship, that lordship had not, lordship, condoned the said misconduct, lordship. In this case, the misconduct was not condoned. But that authorities were directed that if something can be given, lordship, for 10 years, without any break and blemish in the lordship service.
You cannot repeat this.
All the family members, everything is suffering, lordship.
You're
If
suffering
something,
because of
it
your
is
own-
converted to lordship, compulsory
This will
retirement.
be giving, this will be sanctifying forgery. So you should be grateful that they have not proceeded against you in criminal courts by instituting forgery.
In terms, in the line of this judgment, Lordship, if it can be remanded back, then they may once again
Remanded for
consider,
what
Lordship.
purpose?
My humble prayer is that only, Lordship.
You show us something. You show us that there
During-
is a provision which can be applied in.
Yes, Lordship, Rule 22 in, Lordship, while dismissing Rule 22 of the Assam Rifles, Lordship, may come to Rule 22, Lordship. Rule 22 of Assam Rifles Rule, Lordship. Rule 22, Lordship. He has been dismissed under Rule 20. May I read, Lordship?
এখন act দিছে না, rule to লাগে। Regulation.
Rule 22 speaks about, Lordship, the furnishing of, Lordship, the fake documents at the time of enrollment, Lordship. Yes. May I read Rule 22?
Just 1 minute. আমার হেৰি নাই নেকি, বেৰ এক নাই নেকি আসাম ৰাইফলছ? হা? Yes.
Rule 22 speaks, Lordship, that termination of service on grounds of furnishing false or incorrect information at the time of appointment or enrollment. So here the central government or the authority, as the case may be, as specified in Rule 17, may terminate the service of a person subject to the Act on grounds of furnishing false or incorrect information at the time of appointment or enrollment of the person in the service. But here the word may has been used, Lordship. The word the central government or the authority, as the case may be, as
No, Vijay, you want us to clarify that may shall be read as shall.
No, Lordship, that
Then-
since so Lordship, that may be remanded back so that they
So
can,
may is used
Lordship.
perhaps because there may be instances of not false, but incorrect information. There are two instances. One is furnishing false
False, Lordship, yes.
or incorrect information.
False or incorrect, yes, Lordship, that is
So
there.
both will have to be treated. One is not equal to the other. Incorrect information is different. False information is that you have submitted something which is untrue and you know it is untrue.
It was not known to him, Lordship.
That
It was-
information.
That way, I have categorically stated that it was not known to him. So
নাই নাই যদি বনাব দিয়ক কিয় আনা নাই rules as act আছে regulation আছে why the rules are not there তাতে রুলটো নাই না কিয় কৰা নাই
in this judgment also, Lordship, that is misconduct.
where is the judgment of Trilok Singh Rawat
That is,
which is referred here?
yes, that is referred there also.
Where is the judgment?
That will not be referred there. In this matter, so the misconduct was not condoned, Lordship, by the Honorable Court, Lordship. The misconduct was remained as such only, Lordship. But since all the family was because of he was not aware at the time of submission, Lordship. So if the authorities may, Lordship, just they may review or do something, because he will get something, or at least he will get the civil employment. Otherwise, the civil employment has also been curtailed, Lordship, because of the word dismissal. It may be converted to, Lordship, the compulsory retirement also, Lordship.
You show us the judgment which is referred here. Huh? What took you 10 years to detect the falsity of the documents? Why after 10 years?
I don't have. an
Why,
answer.
when the person was inducted, his documents are verified. How did it take you 10 years? You come to page number 22.
22 lots. What's your read petition lots?
Affidavit,
Affidavit.
annexure 4.
And acceptable. Yes, that's it.
The petitioner is at serial number 4.
Four lots, serial number 4.
What is the meaning of all this? I mean, his roll number is found to be in order
Not it.
or not?
Yes, that's about,
Huh?
yeah, 2007, XSLC. False, false. Date of birth and age false. It's the lordship given by the SEBA to the lordship. Date of birth and age false, result false. Result set to false.
What document was sent?
Which lordship?
Mark sheet.
Mark sheet lordship. Mark sheet was for verification.
These judgments are with regard to the second marriage.
Bigaming lordship. But this
Your
is,
case cannot be considered on that.
this is also not that the extreme form of lordship, this punishment. That is the extreme form lordship that makes.
The extreme form has to be forgery. What else? You show us any judgment? You show us anything?
They have allowed me to work for 10 years also thereafter, even after they carried out the lordship, the verifications time to time. So under that lordship, my family.
When was the letter issued?
Lordship. So of course notice, lordship.
When were you terminated?
Lordship on, is at page 22, lordship.
20?
Page 20. Is dated lordship 23rd September 2019. And I joined in on 19th October 2009.
Though they received it in 2018.
Yes, no, after 9 years.
Verification was sent on May 2018.
Yes, after 9
Received
years.
in July 2018. After that, they proceeded.
For 9 years, lordship, they allowed me to lordship, and I also lordship, I was under impression that it was lordship correct. And
you did not challenge it.
If they lordship once again lordship give some other punishment, then dismissal. Because for dismissal, I am not getting any job in civil also. That is the lordship my.
What are the punishments available?
Dismissal is there lordship as for 22 and 17 also.
Under the rules.
Rules.
Or act.
Rules lordship. 22 lordship, rule 22. That is termination of service on grounds of furnishing false or incorrect information at the time of.
No, what are the punishments?
Punishments, that's it. 17, rule 17. 17 members.
17.
17, lordship. No. Punishment, lordship, at. That is that.
You show us some ground to remand the matter back, we'll remand it. You are not getting a job. You show us from the rules that what are the punishments otherwise available other than dismissal. So,
false and forgery, lordship, that dismissal is the punishment. Dismissal is the punishment. For false and false, lordship, false documents.
Then.
Since I served the nation for 10 years without any lordship, remission of it. With some consideration, because no employment, nothing, and my family and I have got minor daughter and mother also lordship. Taking into account of that lordship, they may consider some other punishment.
Under what provision? You go and file an application before the authorities. Have you filed it?
Yes, lordship.
What has been done? Rejected.
Rejected, lordship.
Then, is there any further appeal?
No, lord, nothing.
Then,
no, lord.
You show us some ground
It
for
may
the
be
authority to consider your prayer.
He may be allowed lordship one direction that he may file one appeal like in representation, so that they may consider it if that they may examine again also. The punishments that removal is also there, rule 17 Lordship. Dismiss, remove, discharge or retire all English members. Provision of compulsory retirement can be Lordship.
See, unless you are able to show us that under
Rule
what
17
circumstances this punishment is found to be harsh and what other punishments are there.
Yes, other
It is for
punishment.
the authority to decide.
Yes, rule 17 is there, other punishments. Rule 17.
No, rule 17 is there, but under what instances?
Yes, Lordship, that is instant the
You
punishing
must
of.
be able to find out that the authority has gone wrong somewhere and the punishment is too harsh.
Yes, Lordship, for furnishing false wrong information at the time of the appointment and enrollment. That rule
When
17.
rule
17.
17.
17. Lordship.
What is this?
Termination of service. Lordship got it.
This defines
The persons who was competent, but the Lordship at the table, serial number 4.
serial number 4.
Table. Furnishing of false wrong information at the time of appointment. Who are the competent persons? Then the rule 17, the rule 17 says, Lordship, authorities specified in the heading of the column 3 to 6 table given below shall be competent to dismiss, remove, discharge or retire or release. So Lordship, dismissal has been given, applied in the case of the petitioner, Lordship. My humble prayer is that they may, Lordship, if considering his length of service without any vacancy, he may be made to release, Lordship. That is compulsory retirement. Then he will get something, Lordship, in the civil also. Since only dismissal is not the, Lordship, punishment for this.
Would you show us from the provisions of the act, the rules as to what punishments are available?
In my humble understanding, Lordship, that 17 says the punishment for this is removal, dismiss, remove.
No, we are not inclined to entertain like this. It will lead a wrong precedent.
Lordship.
Can't do that. Unless you show us that, no, for this particular punishment, for this particular action or inaction,
Yes, Lordship.
these are the punishments which are normally given.
So then another date may be given. I'll apply that.
Another date. Why are you people not prepared? I don't understand. And you want all kinds of hearing in the admission column. All hearings in admission column, and when the matter is sought to be taken up, you're not ready. Come on Tuesday.
Tuesday, Lordship.
9th. It's from 9th, enabling the counsel for the petitioner to address the court on place reliance on judgments that he seeks to. And Mr. Answer, it is for the respondent. Yes.
All right.
Item 5.
এখন এক ভিডিও শুন বনাই দিব আপোনালোকক সব কথা কৈ দিব লাগে
The matter is fast over the time.
no timing. You argue.
The senior is on legs, my lord.
You are there, you argue the matter. What is the matter?
That's what.
Discipline.
Discipline proceeding matters.
We had heard this matter earlier.
Last question.
My lord, I have received the records. I have gone through the records, but not thoroughly, my lord. I would not be able to access that today, my lord. It may be fixed on 9th, my lord.
9th.
Long is just, my lord.
Matter be listed in January. Enabling the government advocate to peruse the records also.
We have a copy that, my lord. Copy of that.
Further hearing it as no, I guess. Hearing admission গুলি কিশোর মাধ্যম others we know these are all hearing matters. Further hearing is a further hearing is. ফোন তো পাইছো মই দিব কৈছো যে ইয়াত আৰু কিমান মেটাৰ আছে এইটো ঠিক আছে মাৰক
Lord, as per the last submission, record have already been received.
Yes, yes, sir.
Your lordship.
yes we need some time to peruse through the records. Let it come in January.
People of petitioner does not like, dislike, my lord. I want to have a, my lord, copy of the read petition. I don't have the read petition.
Give it. Let it be in January.
Item 11, 8.
Lordship has fixed a date, my lord.
You not fix the date, you make a mention in January, whenever you want it. What is the point in fixing dates? Once we fix a date, we must make an attempt to close the matter.
I am prepared, my lord.
That's all right, but.
And record has also been received on the last.
What can be done now?
My lord, correct, my lord.
What can be done?
Correct.
So you make a
My
mention.
lord, he's a retired person, so. my lord, considering that aspect, man, I'm praying for a date.
20
Obliged.
20 January.
My lord.
My lord, in this matter, my lord, I have received the report yesterday, my lord. I will go through.
Every matter, why are they, then you should
yes.
file an application before the registry to say this matter should not be listed.
No, my lord, I will have to go through the records, my lord.
That's all right, but these matters are listed today.
Yes, my
If
lord.
you're not ready, then what is the point in listing these matters? You should file an application.
Lord, 9th, my lord, 9th.
Why did you not pray for an adjournment?
No, because, my lord, I saw, yesterday they have provided me the reports, my lord. On 9th of, my lord, December. I'll complete it, my lord.
9 December.
Obliged, sir.
On the request made by the senior government advocates. As the records have been received by them. Yesterday.
Item 9.
Obliged, my lord.
Item 9.
None appears possible.
10.
Wait, sir. But issue in this case is that one of the petitioner before losing is the divorced daughter. She is getting 6,000 per month as a Ongarbadi worker, whether she is a dependent or not. Is the issue. So, madam, in this case, the state government has not defined anywhere, my lord, regarding assessment of the procedure of assessing the dependency.
9 to.
What is the salary that you're receiving?
I'm getting 6,000.
Where have you stated? Where have you stated?
I have stated that, my lord.
But item 9, I was just here, Lordship.
Nobody came forward, so we passed it over.
Maybe pass up for a timely, Lordship, so that it can be taken up.
Yes, yes, we'll take it up, but nobody was there when the matter was called up.
I'm so extremely sorry, Lordship. I was
That's
only.
all right, we'll call it again.
Lordship. Apply.
Paragraph 3, I have stated.
Hmm?
Paragraph 3, I have stated that.
There are 3.
Okay. Is in the relevant portion is page 9, 6, my lord.
6,000 only.
Yes, my lord.
All right.
And her father, my lord, he used to receive, my lord, 11,000.
You are representing whom?
I'm representing Water Resource Department.
Water Resources.
I've given the chart.
Your case has been rejected.
Not rejected, my lord. They are not considered yet, my lord.
They have not considered.
Not considered.
Hmm. There is already a judgment of a coordinate bench.
Yes, my lord.
Where it has held that divorced daughters
Are entitled.
are entitled.
Right. Only objection being raised by the.
Yes.
My lord, in our affidavit, we have taken a stand that in this case, the pension, CCS pension rule 1972 will not be applicable because he was in the state government department and he'll be, her case will be guided by the Assam Service Pension Rules 1969, not
Does
CCS.
it
pension.
exclusively debar a divorced daughter?
No, there is no such thing.
So, and there is a judgment of a court saying that they are entitled.
My lord.
We'll have to consider that. Hmm? Now, only the question is whether 6,000 is good or would be sufficient. You make an inquiry and find out. You are entitled to make an inquiry as to whether the claim of the petitioner that she is receiving only 6,000 is a correct information.
They have admitted that in their affidavit, my lord, they have admitted that, ma'am.
No, we have stated that as per the statement of the petitioner, she is getting 6,000.
No. Not only the statement, you are entitled to make independent inquiry.
My lord.
Her father used to receive, my lord, 14,268 rupees.
Now, we'll dispose it of directing the authorities to effectively dispose of the representation, consider a claim for pension. And if the statement that she is earning 6,000 is found to be correct, then you allow the application. Heard. Mr. I.H. Sokia, Learned Counsel for the petition. Mr. D. Bora or
Appear for 3 and 4.
the counsel for the respondents as well as so and so for the Water Resources Department. The claim of the petitioner is that her late father, late Soneswar Kolita, was working as a khalashi in the Department of Flood Control under the Executive Engineer, Lower Assam, INV Division, Porpeta. Your father expired.
Expired, my lord.
And subsequently superannuated from service on 31/12/2000. Stop. Thereafter, our late father had received pension regularly. In the year 5/3/1990, on 5/3/1998, the petitioner got married. Unfortunately, the marriage culminated into a divorce. And thereafter, she lived with her in her matrimonial house along with her parents. Stop. It is the claim of the writ petitioner that she did not receive any maintenance or alimony from the divorced husband. Stop. her late father was the sole source of income for the petitioner as well as her mother. The mother of the petitioner predeceased her father on 21/6/2005. Subsequently, the father of the petitioner also expired on 23/10/2020, leaving the petitioner alone as leaving the petitioner as the sole legal heir. Stop. The petitioner, he claims to be surviving somehow by working, by rendering service in a local Anganwadi center. And she receives an honorarium of rupees 6,000 only. Stop. The petitioner thereafter approached the authorities, filed necessary applications, requesting for the consideration of her case for grant of family pension. Stop. This did not receive due consideration by the department, and the matter was kept pending. And as a consequence thereof, the writ petitioner has approached this court. The learned counsel for the petitioner submits that the petitioner is the sole legal heir, and the same is not disputed by the respondents. Stop. They have also not disputed the fact that the petitioner is presently surviving by earning an honorarium of rupees 6,000 as an Anganwadi worker. Stop. The learned counsel for the court has also pressed into service a judgment rendered by a coordinate bench. The judgment delivered by a coordinate bench rendered in Hasiba Begum, writ petition number so-and-so, Hasiba Begum. Hasiba Begum. Hasiba Begum. By the judgment dated 30/11/2021. Stop. Pressing the judgment into service, the learned counsel submits that the coordinate bench this court has already held that a divorced daughter is entitled. Divorced daughter who was dependent on the government servant is entitled to family pension subject to such conditions as may be prescribed by the authorities upon being satisfied about the dependency factor. Stop. We submit that the petitioner, being similarly situated, is entitled to an order directing the authorities to consider the claim of the writ petitioner for grant of family pension, and the matter be disposed of accordingly, and the prayer be granted accordingly. The respondent Water Resources Department has. Have you filed anything? Objections?
Well, we have filed our objections.
Has filed an affidavit. The Assistant Chief Engineer Water Resources is filing an affidavit contesting the claims of the writ petitioner. Stop. According to the petitioner, according to the respondents, that under the notification dated 9/8/2018,
Last line of page 44. Page 44, last line. There is no such provision for family pension to divorced daughter.
According to the respondent, in terms of the notification dated 9/8/2018, issued by the Government of Assam Department of Pension and Public Grievances, a certificate of non-marriage and non-employability in the prescribed format, duly certified by the CEO/BDO concerned, shall be furnished by the unmarried dependent daughters to the treasury or the bank once in a year. The respondents submit that this application, along with the requirement of a certificate of non-marriage and non-employment, has not been furnished. That apart, the department submits that there is no official record of any application by the deceased government employee requesting for inclusion of the petitioner's name in the pension papers. So it is the further stand of the respondents that Rule 143 under the Assam Pension Amendment Rules 2018 extends family pension to unmarried dependent daughters, but not expressly to divorced daughters. Thereafter, therefore, the same is not applicable in the case of the writ petition. Indian certificate of good. That we submission. Common Council also submits that under the norms prescribed under the Assam Pension Amendment Rules, a certificate of non-marriage certificate and non-employability certificates are non-employment certificates are mandatory. Stop. There are counsel for the parties have been heard, pleadings available on record, have been carefully produced. Have you furnished a legal year certificate? Yes. Is it here?
Next up is page 24, my lord.
Next, okay.
From the pleadings, it is seen that the petitioner's late father, late Soneshwar Kolita, expired on 23/10/2020. Stop. The legal age certificate enclosed, next of kin certificate enclosed the petitioner, which was issued by the office of the Deputy Commissioner Rongia, by the office of the SDO Civil Rongia, reflects that the petition that late Soneswar Kolita left behind a son and a daughter, namely the writ petitioner. The son is already 48 years and therefore outside the purview of the parameters prescribed under the pension code. So the pension amendment rules extends family pension to dependent daughters subject to any certificate, subject to certificates of being not married and non-employability, non-employability certificates. So, insofar as the writ petitioner is concerned, is admitted that she was married, but which ended in a divorce, and thereafter she had been living in her matrimonial house, her father being the sole incumbent. Father being the sole source of income. Stop. The judgment rendered by the coordinate bench after examining several judgments of the apex court as well as this court concluded that the benefit of pension being extended to divorced daughters being excluded from divorced daughters is unjustified, and the court recognizes the right of a divorcee dependent daughter to receive the benefits of pension by treating her at par to be a unmarried daughter. So, there is no dispute, as is seen from the facts of this case, that after her divorce, the petitioner was not remarried. So the respondents have not raised such objections. So the only point of discord is that the petitioner is employed as an Anganwadi worker and earning a normal wage of 6,000 rupees. So since the question of a divorced daughter being required to be treated at par as an unmarried daughter has already been decided by a coordinate bench, and no further appeal as stated in the bar has been preferred against the judgment. The judgment has attained finality. Therefore, it has to be held by referring to the same judgment that the rights of the writ petitioner as a divorced unmarried daughter is to be treated at par with that of an unmarried daughter in making her claims towards pension. So, insofar as the claim for unemployment certificate is concerned, there is also no dispute at the bar that the petitioner is earning rupees 6,000 only. As honorary. Taking into consideration the continuous hike in prices and the cost of living, it has to be held that honorarium of rupees 6,000 would not be considered to be sufficient for an individual to carry on decent, respectable life. So the question of employability has to be understood in the context of offering gainful employment so that the person concerned is able to earn an income which would be considered sufficient to ensure that the person and his dependent members are able to carry on their lives without being reduced to penury. So, taking into consideration the cost of living index, which is available in public forum, this court is of the considered view that an income of rupees 6,000 is by no means can be considered to be an income sufficient to ensure livelihood of a person or his or her dependent family members. Stop. Mere income receipt of some income cannot be or should not be construed to be employability in the context of the provisions of the Constitution, enshrined principles of the Constitution. Stop. The employability as prescribed under the Assam Pension Code has to be understood in the context of an employment which would be considered to be at least minimally sufficient to ensure a person is able to survive with the income that he or she earns. Stop. This court is of the considered view that an income of rupees 6,000 by no means can be considered to be an income which will ensure sustainability of the person concerned. Therefore, this honorarium of 6,000 received by the Anganwadi as an Anganwadi worker by the petitioner cannot be termed to be an employment as conceived under the Assam Services Pension Amendment Rules 2018, which is amended by notification dated 9th of August 2018. So, under such circumstances, the department will now examine the case of the petitioner for consideration of a case for grant of family pension in terms of her claims made towards the benefit of family pension in respect of the services rendered by her father, late so-and-so, as a government employee. So, the department, however, is entitled to make a thorough inquiry into the matter before issuance of appropriate orders on the question of dependency over the status of being unmarried after divorce by the petitioner and the sources of income available to the petitioner. So if the department comes to a finding that all these three conditions are suitably met by the petitioner, then the fact that the petitioner is earning an honorarium of ₹6,000 should not be considered as a hurdle to deny the claim by the petitioner towards family pension. Let these exercise be carried out within a period of 90 days from the date of receipt or certificate of this order. The petition stays disposed allowed. Respondent 5.
DPF and DCRG we have already paid.
If she's entitled to pension, it's for the administrative department to decide.
That will be decided, that dependency certificate is to by department concerned will send us. If they satisfy, because we have no one to say on this point, once we get it. Right.
Madhuri.
That is nice.
I have some difficulty today, my lord. Can it be on 11, my lord? I'm not praying for
Not-
mass, my lord. On
I'll
11.
just, I'll just point out to your lordship, the affidavit that you have filed, in the last lordship at
There's some
Black
interim
F.
order.
There's some interview.
Let it come in January. 11th is not.
No,
possible.
lordship kindly turn to flag F. Last,
number
last affidavit, page number 180.
150.
Lordship,
Yes, the Supreme Court-
on 188.
Order
The Supreme Court's order is there,
158.
directed
to complete the inquiry process.
inquiry within 6 months.
6 months.
And 2 months have already expired, lordship.
Where is that order?
Lordship,
Page number
157, my lord.
157.
page 157. This is the last affidavit we have filed.
The pendency of the writ petition was not brought to the notice of the honorable court, my lord, 12% is order. Even then, my lord, next week, 11, my lord, it was possible.
No,
Or on 9th.
Let us complete the test.
No, what is the challenge here?
My lord, my lord, they initiated such a proceeding twice, my lord. Each time, my lord, they have dropped the proceeding. Now in 2022, right from 2014 to, my lord, 2022, twice it was initiated and it was dropped. Now in 2022, my lord, they have again, my lord, issued notice to the petitioner and they are trying to, my lord, initiate a process. But, my lord, the act or the rules, my lord, nowhere, my lord, empowers them to, my lord, initiate after, my lord, 3 times, my lord, or even 1 time, my lord.
So the Supreme Court has directed.
No, it's regarding proceeding, my lord.
What proceeding?
This is the part of the
Departmental
proceedings.
There is no such department proceeding. Once department proceeding in so-called was issued, search memo was given to us. Thereafter, my lord, it was suo moto, they withdraw it, my lord. It is there in the writ petition. my lord.
No, you're asking for setting aside the inquiry report.
Inquiry report and thereafter, my lord, they want to again, my lord, conduct it. I will show it, my lord, only. Let it be, my lord, I am led by the senior counsel, my lord, Shekhia. Let it be on, my lord, 11th or. my lord.
We are asking you only one
Yes,
thing because the Supreme Court has directed the proceedings to be initiated.
Yes. My lord, what has happened is, my lord, the entire issue, my lord, from this honorable court went to the honorable Supreme Court was regarding, my lord, the suspension part. This honorable court interfered with the suspension, my lord. Before the division bench, my lord, that order setting aside the
No, we are
suspension
not
was
opening the
after.
matter. We just want to
No,
understand.
I am saying that's
that-
right, my lord. What has happened, what went to the honorable Supreme Court was only on that point.
No, then the court has also indicated the proceedings before the High Court be expedited. Page 158.
My lord.
Proceedings initiated by the delinquent officers.
My lord.
Pending consideration before the High Court are expedited in terms of the earlier order. What is that earlier order?
1410. I think it is 1410.
29-7, what is that order?
Yeah. I don't know.
Lordship will finally hear it after 11 men.
Criminal matter,
11.
they got the criminal matter which is fine, criminal petition which is fine.
Is that criminal petition?
There is
That was connecting the criminal petition independently lying, Lordship. This is nothing to do with.
You don't know, there's a reference here. You are pointing out to this order. It contains a reference to an earlier order.
Yes.
What is that earlier order?
My lord, in fact, my
We'll
lord,
have it in January. January.
They were also part of the Supreme Court.
20 January,
Well,
22nd January.
22nd, my lord.
Not Lordship, in that case, our problem is that the DP which has been initiated in 2022 stayed because of this interim order passed by the Honorable Court. So that DP has to be concluded within 6 months. We counted date to be counted from 6th of Lordship September 2025. So that will be expiring in February. So DP once started, it will be taking some times. Therefore, this ICC's that what
See,
that
you all, the matter was last listed on 30/10.
Lordship.
You all of you agreed to have it on 4/12, which is today.
Lordship.
Now, again to reschedule it and have it on 9th and 11th is not possible for the court. We can
will be
only
on
give you a
22nd.
date in January.
Yes.
Not for January. Sir.
You come back on 6th of January, 8th of January.
Point out.
Heard counsel for parties, Mr. D.B. Gogoi, learned
Well,
additional
counsel for the-
appearing for the state submits that the matter,
Finally to be.
No, not for the state. my lord.
then Mr. So-and-so, counsel submits that is led by Mr. D. Soikia, senior counsel. Is not available today and seeks an adjournment. Mr. R.P. Kakoti, senior counsel appearing for the respondents on the other end submits that there is a great urgency in the matter, as the Supreme Court has directed expeditious disposal of the proceedings. Therefore, as agreed to by the parties, list this matter on
6th of January, Lordship.
8, my lord, let it be 8. On 8. No, yes, 8.
6th.
Lordship. 6th, any day 6th or 8th, Lordship, not that.
8th,
Lordship, kindly,
8th of January.
Lordship, that will be. But it may be kindly observed that it will never be adjourned anymore. It has been adjourned
An
continuously.
attempt will be made to dispose of the matter
There is no opposition from our.
on the next
There is not
date.
concentrated.
The interim will continue to
Interim orders passed early will continue.
oblige.
The VA said that the parties have agreed to the deal. He is recorded, sir.
Yeah, also. So last occasion will
What is the challenge here?
Lordship, we are challenging here the dismissal order as well as the appellate order, which was passed culminate from the disciplinary proceeding conducted in ex parte. And that too, my lord, the so-called disciplinary proceeding was conducted in violation of rules, my lord,
Violation of?
rule 9 of rules.
My lord will note one thing, ex parte pilot. That part, my lord.
Yes.
It
That
was
is,
ex parte.
Yes.
his grievances, my lord, we have gone ex parte, my lord.
Not only ex parte,
My lord will note that, my lord.
my lord, very initiation of disciplinary proceeding was in violation of the rule 9 of 1964 rule. My lord, if he's Lordship, petitioner is the regular employee of respondent department, my lord. He is appointed in the 19.
Where is the show cause?
Lordship will find the show cause notice as page 64. My lord. '64, that is dated 4/9/2012. my lord.
So you were transferred, you did not join.
Lordship.
Then
Lordship,
what is your reply?
Lordship, that part, my lord, then I have to start from transfer order, my lord. Lordship, on 19/5/2000, while working the petitioner Milot as a LDA Milot in Responder 4 under Responder 4 Milot, he was suddenly served a transfer order 19/5/2010 Milot. And prior to that, Milot, on the 18th, some altercation or some took place between the petitioner and accounts officer of the respondent number 4 Milot. And subsequently, Milot, that on 19/5/2010 Milot, transfer order was issued. Because that transfer order is at the behest of the accounts officer, and accordingly, petitioner submitted a representation Milot, that that was not in public interest, but it was at the instigation of accounts officer Milot. That is that had been admitted by the respondent, that will reflected in the inquiry report Milot. And subsequently, Milot, petitioner stood release. Immediately it stood release. And in between, Milot, some.
You filed appeal?
Yes, Milot.
Rejected?
Rejected. Even Milot, this proceeding cannot be maintained. It appears to be a preliminary inquiry. Milot, what happened, Milot, as per Rule 9, Milot, if disciplinary authority or employer desires to impose punishment, the charge sheet with specific charge has to be served upon petitioner. But in this case, Milot, an inquiry committee was constituted to get inquiry into the matter of transfer, Milot. Highly note, Milot, matter of transfer. And subsequently, Milot, show cause notice was issued, Milot. And it is the rule of mandate of the Rule 9 that disciplinary authority is to issue the show cause notice, and after submission of reply, Milot, if he is not satisfied, then inquiry, he himself to be inquired into the matter or may appoint inquiry officer. But in this case, Milot, inquiry committee was constituted by chief engineer, respondent number 3, Milot, to inquire into the case of the transfer. And subsequently, Milot, show cause notice was issued without mentioning the list of date and list of witness. And that was issued on 4th of September 2012, which was received by the petitioner, and whereby, Milot, petitioner directed to submit reply, Milot, on 14th, on or before 14th. That show cause notice was received by the petitioner on 11, and accordingly, Milot, on 14th, petitioner submitted revision before the disciplinary authority that I received this on such and such date, and we need some time. Moreover, Milot, it was mentioned that to effective reply, there is no mention of list of date and list of witness. So, to reply effectively, these are to be furnished. And accordingly, Milot, that was submitted to the disciplinary authority. And by that time, Milot, inquiry officer appointed, Milot, issued notice to the petitioner to appear before him, fixing a date on 2012. But subsequently, that was that day inquiry is not held because of Bharatban called by some organization. And subsequently, no notice was served to the petitioner. And thereafter, the inquiry report was submitted to the.
No, the show cause notice is at page 64.
Yes, Milot.
It is supported by statement of allegation.
Yes, Milot.
And list of documents and all.
List of documents not mentioned or not relied upon.
Right.
Whereas in the inquiry, total 14 numbers of documents were relied upon by the inquiry officer, and 9 witnesses were reduced and recorded their statement. Moreover, possible if go to the search, mention it as search data not specific, more particularly, Milot, search number 2, Milot. It is the settled law that search to be specific, not vague. But here mentioned that some documents were displayed, but what document were displayed, that was not, it is not clear. And there is no search which regard to, Milot, Rule 15 and 21. But in the inquiry, inquiry officer held the petitioner to be violation of Rule 15 and 21 of Assam Services Contact Rule. The inquiry, no opportunity was given because no notice was served to upon, because since it was fixed earlier on 2012. Subsequently, that inquiry was not held, and subsequently no notice was issued. And next day, very next day.
First it was, you notice was issued on 12/9.
Yes, Mr.
You were asked to appear on 29.
29. Yeah.
Then?
Then lawsuit will find that kindly see page 70, Miller.
So 67 is an application
Yes,
by you.
Yes, Miller. I submitted to seeking time. And last paragraph, Miller, lawsuit will find that mentioned that no document, list of witness were furnished to the petitioner. Miller. And lawsuit will find 69. It is the letter submitting the inquiry report. Lawsuit will find an enclosure, inquiry report, exhibit 14 exhibit evidence, 14 of numbers, oral statement 9 numbers, oral statement DW. Who is the DW? I don't know. And that expert inquiry was held on 22nd of December in absence of petitioner, without giving any notice. And if lawsuit go through the inquiry report, lawsuit will find there is no finding at all, Miller. Only on the basis of facts, Miller, he concluded that petitioner is search mentioned in the search sheet as well as some other search has been proved against the petitioner. And accordingly, Miller, punishment has been proposed under Rule Miller 7(6) and or 7(7) of Assam Services Disciplinary Rule. Accordingly, on the that inquiry report, basis of that inquiry report, Miller, disciplinary authority passed the impugned order at page 75. And as per Rule 9, Miller, disciplinary has to consider and record reason against each of the search, Miller. But if lawsuit will go to the inquiry report, lawsuit will find there is no consideration, independent consideration of mine, Miller, by the disciplinary authority. Only on the basis of inquiry report and approval of a higher authority, Miller, this order was. There is no reason recorded by the disciplinary authority. More than that, Miller, it is a settled law that disciplinary cannot be a witness in a disciplinary proceeding, Miller. Whereas in this case, disciplinary adduced himself as a witness against the petitioner, Miller.
Yes.
And thereafter, Miller, petitioner several litigation was and that has been decided by the dishonorable court, and subsequently, as per liberty granted by the dishonorable court, appeal was filed. Lawsuit will find the appeal at 84, and all these grievances were mentioned that was filed to the commissioner secretary, and that was decided by the chief engineer. Perhaps it was delegation of power, Miller, at page 108, Miller. In appellate order 2, Miller, there is no consideration. Only basis of the report submitted by superintendent engineer who was inquiry officer in the disciplinary proceeding, and this my appeal was rejected. That's page 109, specifically mentioned that superintendent engineer so submitted view that there is no additional view on the ground of appeal petition submitted by the delinquent official Dhanjit Das for reconsideration of matter, whereas this superintendent was the inquiry official. It is, disciplinary proceeding is the procedural proceeding, it has to follow all the rules and regulation and principle of natural justice. But, and inquiry officer supposed to be, not supposed to be a representative of department, but is supposed to be the act as a independent adjudicator. But in this case, my lord, inquiry officer acted at the behest of the petitioner with predetermined manner, my lord. Inquiry is conducted without giving any opportunity. And inquiry was submitted on that basis, my lord. I was terminated from service, dismissed from service. If lordship peruse the order of chief engineer whereby inquiry was considered, it appears that it's for a purpose of preliminary inquiry, this committee was constituted. And
Which order of the chief engineer?
lordship page 63.
63.
On the basis of preliminary inquiry cannot be imposed punishment. May I please read me? In partial modification of the office order that so and so, Sri A. Borua, superintendent engineer, planning of this office hereby appointed as inquiry officer to conduct an immediate inquiry into the case in connection with the transfer, not the search. Misconduct, my lord. That is why, my lord, it may be a inquiry officer to conduct the preliminary inquiry.
Where do you find the word preliminary?
No doubt, no mention, but transfer, but in the
Transfer, that
Yes.
that is relatable to charge one.
lordship, but this constitution of this inquiry committee, my lord, has to be come after searching, my lord. As per rule 9. That's why it's can be presumed that this is for only for the purpose of conducting preliminary inquiry, my lord.
What is the date of constitution? 1st September.
Yes, my lord. And lordship will find next page 64, my lord. This is the so cause.
Yes. You never filed reply.
No opportunity given, my lord, because lordship will find that page, my representation that 67. I seek reasonable time to reply, my lord. And that representation was placed before the inquiry officer. Lordship will peruse for a moment, my lord, at page 72, my lord, a part of inquiry report, my lord. 72, second paragraph. It has been submitted by executive engineer on 21/9/2012. That is on the day of expert inquiry, my lord. That the delinquent official Dhanji Das sent an application through register post in respect of so cause notice dated 4/9/2010, a statement of obligation, which has been received by executive engineer 21/9/2012, copy of so. That means that was produced, my lord. After receipt of that, no opportunity was given to reply. No time was given. Not he proceeded for expert, my lord. And reason for expert, my lord, mentioned in the inquiry report, there is 71, last paragraph, my lord, that a notice was issued for postponing the proceeding, my lord. But that notice was never reached to me, my lord. They claim that, my lord, the notice was affixed in my wall of my house, my lord. On the day of, on 2012, my lord, which date the Bharat Manda was there, my lord. Yes. Without following all this, my lord, rule 9, my lord, this proceeding was conducted. And lordship will, if lordship go to the inquiry court, there is no finding, no reasoning, my lord, only on the basis of, my lord, and very initiation is that he is acted at the behest of the, as a superior authority of the department, my lord, and permitted this report.
Yes, respondent. He'll come back to you.
Yes.
Yes.
My lord. My lord, here is the thing. My friend was all along, my lord, during the inquiry, was trying to play hide and seek. My lord, numerous communications was sent to him, notice, statement of allegation, my lord, he never responded. My lord will take up my affidavit in opposition filed by the respondent number 4. In page number 135, my lord, the running page, my lord, we are so exhausted to trace him. In page 135, my lord will find a notice through the Director of Information Public Relation, my lord. We had to, my lord, come up with a paper publication in all the newspaper. My lord, I have the paper cutting, I have gone through the records, my lord, and it is there. That you come and join. My lord, all along, he was, my lord, running away from the inquiry. He was not appearing, my lord. And my lord, now he comes and he, my lord, alleges that it has gone ex parte, my lord. How do we, my lord, catch him?
Firstly, after he submitted his application seeking further time, was any further time enlarged? Page number 67.
Page number 67, my lord. डेट किती असेल ना डेट तो नाही आहेत ना
सोबत आहे
नाही आहेत म्हणे তোমার নাই নাই এইটো তোমাৰ ডেট দিয়া নাই না
তাতে দিয়া না তোমাৰ ইনকোয়ারি রিপোর্টও মেনশন আছে এই নেক্সট পেজত পাই
It's not available with you.
My lord, I'm trying to find the records, my lord.
No,
Not
no.
there.
It is. Find out from the reports. We'll call up after a while. Second half of judgment doesn't. You can. File to engine nine. Already.
Well, here petitioners challenge the appointment of the respondent number 8 as Anganwadi helper. Well, Lordship will find the advertisement, Lordship. Advertisement is at page 23, madam.
Lordship, we have filed an affidavit with some record.
The page 24, my lord, 11%, my lord. The conditions, my lord. Applicant should be a resident of the area of a particular Anganwadi center for which she wishes to apply for the post of Anganwadi worker and helper. And there should
What
be
is the
cert-
center? What is the center name?
center name was Hotepo Abori. Lordship will find that page 24, serial number 11.
20?
24 itself, Malad.
All right.
247 Hotepo Abori. It is the district of Baksa. So, Malad, she should be a resident of that particular area, Malad. And an application should be accompanied with certificate issued by the village pradhan and of the Malad certificate of residence signed by the Anganwadi worker for where she applied. Malad. And Malad, Lordship will find below Malad serial number 5, the candidate should not be a regular student of any college or school. So, Malad, and next page, Malad, page 25. Serial number 6. If the candidate is a regular student of school or college, Malad, it's entitled for a cancellation of her Malad application. Page 25, Malad.
25.
Page 25. Translated type copy. Serial number 4. If the candidate is a regular student of any school or college, then her application will be cancelled. Now, my lord, Lordship will find that page 35, Malad, Annex 7. It's a comparative statement, Malad, comparative statement of the candidates. Serial number 9, Malad.
Page number?
Page number 35, Malad, Annex 7.
35.
Serial number 9 is the petitioner, Malad, Anjana Devi. And Lordship will find at the remarks column, Malad, her residence is nearest to the AWC, though she is second in merit position, but selected. The first position candidate is regular student. Lordship will find the first position candidate, serial number 7, the respondent number 8 here in Mitali Das, Malad. She is a regular student at IYDE Academy, Ihu. PA first semester of that so and so, admission date is so and so. So, Malad, she was found to be a regular student. So that is why initially, Malad, comparative statement, present petitioner was shown to be selected. And thereafter, Malad, Lordship will find that page 37, Malad, Annexure 8. Serial number 3, Malad. Respondent number 3, 8, sorry, Malad. Respondent number 8, serial number 3. Highest marks in HSL, remark column. Highest marks in HSLC among the candidates and suitable for the post.
Page number?
Page number 37, Malad. So respondent number 8 has been selected. Serial number 3.
And where is the name of the petitioner?
Petitioner has not been selected, Malad. This is the final select list.
Respondent number?
Respondent number 8, Malad. Serial number 3.
Yes.
So, Malad, this select list has been, Malad, issued, final select list, pursuant to the Malad, minute. Lordship will find that page 38, Annexure 9. Annexure 9. Although, Malad, here, Malad, in the top, Malad, top of the Annexure 8, it is shown that the meeting was held on, Malad, 5th of December 2022. Perhaps, Malad, that Malad, year has been wrongly quoted as 2022. It should be 23, Malad. Anyway, and Lordship, thereafter, page 39, Malad. Page 39. Approval, Malad. Approval of the selected candidate for the post of Anganwadi helper. Which may read, Malad. Page 39. With reference to the subject cited above, I am to inform you that as per instruction and recommendation of the council level empowered committee BTC Kokrajhar, with minutes referred above, dated 7/9/2024, received 5 letter under reference dated 23/10/2024. Selected candidates for the post of Anganwadi helper, number 1, submitted video letter under reference dated 19/8/2023 is hereby accorded approval for accepting voluntary service of Anganwadi helper for the Anganwadi center shown against her name as follows. The name of the Anganwadi center is shown at page 40 to 47. Anganwadi helper, respondent number 8 has been appointed. Now, my lord, I have found, my lord, after my lord, RTI application, her application certificate, my lord, lordship will find that page 46. She is not even the resident of that particular Anganwadi center, my lord. Page 46 is the vernacular, my lord.
Page 40.
Page 46, my lord, vernacular. My lord, below it is written, this certificate issued by the, my lord, Gaubura, my lord. এও বিবাহ সূত্ৰে আন ঠাইৰ বাসিন্দা হয় যদিও বৰ্তমান উক্ত ঠিকনাত বাস কৰি আছে originally she is a resident of that particular area my lord but after marriage she become resident of another place my lord
But her, thereafter, I think her marriage was dissolved.
Dissolved.
it was subsequent my lord my lord at that time her
When was the selection done?
selection was, my lord, last date of submission of application was, my lord, 15/6/2023. And advertisement was issued on 2/6.
Marriage was dissolved.
Marriage, my lord, yes.
But how can it be
in
dissolved
her
by mutual agreement?
My lord,
Marriage is dissolved by mutual agreement.
my lord, kindly see, my lord, her application, lordship will find that page 32. Page 32 is her application form, my lord. She has written her status as divorced. And this application was submitted, my lord, prior to
Who has filed this affidavit?
Which one, my lord? One affidavit is filed by BTC, my lord, by our predecessor.
Respondent 6.
Yes.
Who is
Ship,
respondent 6?
R6 is BTC, officers of BTC. R8, he is representing.
6 is BTC.
Yes, my lord.
How have you accepted this agreement saying that the marriage is dissolved? Come to page number
54, my lord.
51. Translated copy of
Oh,
54.
Oh, there are clauses, my lord.
Huh?
Lordship, there's a clause 4, condition number 4, page 52. Both the parties will jointly file a mutual
No,
divorce
what
petition.
is it an order of the court? How can a marriage be dissolved by mutual agreement?
True.
Then how have
But
you
they have
accepted-
certain terms
accepted
and
filed
conditions.
it in your affidavit?
Lordship,
You have accepted it and brought it on record by way of an affidavit. Is the notary authorized to dissolve a marriage?
some places, my lord, it has happens.
Huh?
Some places, my lord.
Some places. Then we have to issue orders cancelling licenses of these notaries. How have you issued the cancellation?
Legally, it's not legally enforceable document. But your lordship, some places, notary, it's.
Forget some places, why the BTC has accepted this and brought it on record?
Lordship, because I didn't file it, my
You don't know
predecessor.
who is filed it, you are appearing now.
My lord.
You are representing BTC. You are relying on this affidavit.
My lord.
How this document is valid? And you have proceeded to say that the respondent 8's marriage is dissolved.
I haven't made my submission yet.
No, that is what you're saying in your affidavit.
Yes, just look.
What are the conditions in the advertisements?
advertisement, lordship, will again come to advertisement page, my lord.
24.
Page 24, my lord.
Resident.
The applicant should be a resident of the area of the particular Anganwadi
Resident
center.
of the area.
Yes.
Okay, then
And my lord, certificates,
Certificate
my lord, by the.
Date of advertisement.
center area
2/6.
could not be a regular student.
Yes.
So is there anything to do with marriage?
My lord, the advertisement was issued on 2/6/2023. And last date of submission was 15/6/2023, my lord. And prior to that, my lord, marriage was still surviving, my lord,
No,
even
the
if.
whatever agreement say. No, but where is the condition that if she is married, she cannot?
But I am not on that, my lord. By way of marriage, my lord, she become resident of another place.
May not be.
May not be. She may be married somewhere, she can come and stay in the.
And contest lordship to give her vote, she can come to a native place.
My lord, after she become resident of other district, my lord, that is what I am submitting. That is my
Submission
instruction.
on the basis of facts.
Yes. So, my lord, because even if, my lord, as per agreement, my lord, as per agreement itself, my lord, advertisement, my lord, post was at, my lord, Buxar district, and she got married with Bajali district, my lord.
Where is the minutes of the meeting?
Minutes, lordship, at page 38, my lord.
So the only ground is that she was married.
No, my lord, she is a resident of other place and she is a regular student.
A regular student.
On that ground, my lord, her comparative statement also specifically mentioned. That is why petitioner was selected and the respondent number was not selected. And my lord, the information furnished in the application form, my lord, that her marital status, she has stated divorce, my lord, that is also false. Lordship, I have obtained some certified copy of the, my lord, cases pending against the respondent and her husband. That divorce suit, my lord. The divorce suit was a written statement filed by husband, filed by wife on 7.
Is it a divorce?
No, well, that case is still pending because the written statement was filed only on 17/1/2024.
That is not conclusive of the fact that she does not stay in her matrimonial house.
But my lord, her status, my lord, as reflected in her application form, she has
Where is the application form?
at page 32, my lord.
32.
And vernacular at page 34, my lord.
32.
Page 32, serial number 5, my lord, applicant. Divorce.
Maybe. If she is divorced.
Not divorce, my lord, because my lord, application 15/2023.
Where is the material to show that even if she is married, she cannot come and stay in her own matrimonial house? She may like to do
I'm
that.
not on that, my lord. I am on the submitting false information, wrong information.
No, but you submit that there is some matrimonial dispute going on. Some litigation
One
is going.
suit is pending, my lord, but divorce suit is pending. But my lord, on the date of submission of the application, her marriage was.
She was not divorced.
Not divorced.
But the question would be, how is it relevant for choosing it? Unless you say that no, under this particular.
On that count, my lord, furnishing false information, wrong information itself, my lord.
Wrong information, but how does it affect the status of the candidature of the petitioner?
Candidature, my lord, after marriage, she become domicile of her husband, my lord.
Under what basis are you making this claim that she must become a domicile? She must be a resident of that particular area. Under what law?
On that ground
That is
only,
ordinarily,
now, my lord,
that is ordinarily accepted.
to substantiate that she is residing in her, my lord, parents' house, that is why she submitted this mutual agreement now.
That they have made inquiries and found correct. They have made inquiries and found it correct. The only thing was that she was a regular student of so-and-so academy, BA first year. Is she a regular student?
I am not aware, but it is from the, my lord, comparative
What do you say,
statement, my lord.
PTC?
Lordship, we have stated in our affidavit, my lord. Stated as a regular student at IYDE Academy Tihuda Selection Committee after we come to know that she was not a regular student, but for a correspondence course arranged by IYDE Academy, para 4, we have stated.
Is there any document to that effect?
On document, Krishna Kanda State Open University's admit card is given, your lordship. Page 60. Lecture D. And my friend who is appearing for R8 be directed to file his affidavit and put his stand, madam.
You have to substantiate this statement. Page number 49. That she is not a regular student On what basis?
Lordship.
What basis have you made this statement? What documents are available? Because in the selection list, there is a categorical finding by the selection committee,
Yes, my lord.
page number 35,
My lord.
that she is a regular student. So this must be on the basis of some documents.
Case number 35.
Yes.
Yes, my lord. Both the things can't go together. If she is a regular student, she cannot be selected.
Mr. Ahmed? After hearing, what were you doing all this time? Why did you not approach the court, make a prayer that you want to file?
Argument is going on, that is why I.
Oh, so you wanted to hear what arguments are going on, what they have to say, now you want to file it. This is not done. This is highly unbecoming of a conduct of a council. You allow the hearings to proceed and then you stand up to say that you want to file an affidavit. Why did you not make this submission at the outset? You're still working now. You're working.
Abhi kaam kori aise nahi.
So that you file it within whatever time, 2 weeks?
3 weeks.
Huh?
3 weeks.
3 weeks. Why? Heard counsel for parties. Although the matter was taken up for hearing, after the matter was heard at some length, the counsel for the private respondent number 8, Mr. A.N. Ahmed, submits that he would like to file an affidavit to bring on record some information with regard to the fact that the petitioner is not a regular student of, what is that,
EY.
IY.
IYDE, Academy of Tihu. Rather, she is enrolled in a correspondence course under the KK Hendig Open University, IDOL, etc. Let this affidavit be filed immediately within 3 weeks. Matter be listed thereafter.
Lordship, there's a status quo order operating as my learned friend has shown.
Status quo.
Yes.
So status quo order will continue. Who is working now?
25/4/2025, Lordship.
Who is working? Who is serving?
She has joined, respondent number has joined, but salary was not released at that time. While passing the the status quo order, salary was not released at that time.
So you're not receiving salary?
Apne dharma pa aise nikli.
Status quo order, if any, will continue till the next day. List the matter on 19 July, 19 January.
Obliged. BTC may also file.
You have already filed.
Clarifying the stand with me also.
You feel like you do it.
Supplementary base for additional item.
Lordship, here in this, Lordship. Yes, Lordship, here in this case, Lordship, today, Lordship, I am going to file the affidavit, Lordship. Today, Lordship.
Your Lordship, I think affidavit is not necessary, Your Lordship. Your Lordship kindly see.
Necessary or not, he is going to file it.
Yes,
let him file.
Only the matter is the delay, Your Lordship. It is squarely covered by Ajay Chaudhary, Your Lordship. Your Lordship may kindly appreciate one thing, Your Lordship.
You are under suspension.
Yes, for more than 2 years.
2 years.
Yes.
No DP.
No DP.
Conviction, convicted lordship. He was
Convicted state.
convicted by the special judge.
And what is the
Poxo lordship.
punishment?
Lordship,
Let
7 years lordship.
7 years.
Yes, lordship.
Then
state.
No,
But it's not
no,
about-
stay.
by an
not-
appeal,
No, no.
Yes,
in an appeal.
The execution is stay, not operation is state lordship.
state
No.
and also granted bail.
No.
Let me submit my,
It's only stayed, not set aside.
Yes, not set aside lordship.
state means,
No,
It means not to be given effect to,
yes,
no.
but it doesn't mean that it
You are,
is gone out
you are
of
not guilty.
existence.
Yes.
what your lordship, if your lordship may draw analogy.
Let me
kindly-
file the
There is no
affidavit.
analogy here. There is a conviction, that conviction has not been given effect to.
Yes,
It
and
doesn't,
also I have been released on bail. Bail order is also there.
maybe you're on bail,
Yes,
but the stay is not
So-
equal to interference.
so appeal, your lordship, appeal is a continuation of suit.
Hmm.
Your lordship is quite aware of your lordship. So since the appeal is pending, your lordship, it may go decided in either way,
Right.
your lordship.
Hmm.
So what will be the stand, your lordship? So suspension, what is the rule governing suspension, your lordship? I have been placed under suspension, your lordship. Kindly see, the impugned suspension order is 8/1/2024.
Hmm.
So requirement is within
Have you
this
instituted departmental proceeding? Where is the suspension order?
order annexure 11, page 57. Kindly see, your lordship. Page 57.
Yes.
Page 57. So, Mr. MD Negabuddin Ahmed so-and-so is hereby placed under suspension as per Rule 6(2). It is also ought to be taken into consideration. So there are some rules with effect from 1/11/2023 on the date of his arrest, as he has been kept in police judicial custody for more than 40 years.
When did you inform the authorities?
Yes, I informed the authority, I have been released on bail on 13/12/2023. Your lordship, then there are
When did
yes,
you,
para 8. I got released on 13/12/23.
when did you inform the authorities that you?
On 16/12/23.
By which communication?
By Alexa, para 8 statement is there.
No statement, where is the
Who
communication?
proceeded it to the respondent number 2 and prayed for his reinstatement. It is in fact after my informing the authority, they have issued the suspension order.
No.
Yes, I have made a categorical statement.
Yeah, all right. How
Yes.
they may not be aware that you were suspended, you were arrested. How do
Yes,
they know?
yes. Okay, your lordship. They became aware and they
Now,
subsequently,
what about the departmental proceedings?
Lordship, a statement of allegation was served, lordship. So cause was served.
When?
it was served after 3 months, your lordship.
It is
After 5 months.
14/6/2024.
14/6/2024.
What is the
Annexure
stage now?
10. I have submitted reply.
No,
What is the allegation?
Let me file my affidavit, lordship. Today I will, I will file, lordship, today itself. Lordship, kindly list the matter for admission hearing, lordship. I will apply. Sir.
Your lordship, kindly appreciate my, allow me, your lordship.
Are you receiving subsistence allowance?
Substantial allows.
Yes or no?
Yes, I think. Now, one thing your lordship may kindly appreciate, your lordship. Within 3 months, they have to submit the memorandum of charges, your lordship. When they have submitted the show cause notice, 14/6, that is after 5 months. 5 months, Ajay Chaudhary judgment covered. Then
No, Ajay
even
Chaudhary
after
is
show
not-
cause, even after show cause,
You file your affidavit.
they have to,
We'll
they
take
have
it up
to,
on- tell us when
they
you
have
want-
to review the matter and extend the suspension. That is also not there. That is also not there.
When will you file your affidavit today?
Today, lordship.
Yes, tell us when you want it.
Any day, you know.
Any date.
I provided, I will see the affidavit, if necessary, I will submit a reply. you know. After 1 week, after
You,
1 week.
you file it, then
Yes.
we'll hear you in January.
Can it be on the last week of December? Your lordship?
Last week of December.
It will be holiday.
Vacation.
Sorry, before
Before
closing,
vacation.
18th? Today is 4th, your lordship. 18th, your lordship.
11th December.
Lordship.
11 December, list on 11 December. The learned counsel for the respondent will has submitted before the court that he will file an affidavit during the course of the day. Stop. Considering the submission made and the urgency expressed by the counsel for the petitioner, matter be listed on 11th December. এক মিনিটত কি করা আপনি?
For judgment pertaining to examiner by 56/4/6 of 2023.
Writ petition dismissed, interim order if any stands vacated, pending IAs are also dismissed.
WBC 6 of 2024.
Under such circumstances, court is not persuaded to accept the submissions of the learned counsel for the petitioner that direction should be given to direct the respondents to pay compensation. While it is true that the amounts claimed by the petitioner have not been disputed by the respondents, the petitioner shall be at liberty to pursue such remedy before appropriate forum in accordance with law. This court is not inclined to decide the matter on the question of compensation as urged by the petitioner before this court. However, considering the fact and taking into account the submissions of the learned government advocate for the state of Arunachal Pradesh that the claim of refund and interest of the writ petitioner are already under process, it is expected that the state respondents will make endeavor to expeditiously release the refund payable to the petitioner, preferably within the limit of 4 months from the date of receipt of a certified copy of this order, if such claims are already admitted and accepted by the respondents. Writ petition disposed of in terms of the above, no order is to cost.
Yeah, please, your lordship, my lord. Your lordship, permit me, my lord. Just make a mention of item number 16, my lord.
Mentioning is at 10:30.
I know, my lord. Just that's why I sought for permission, your lordship.
No, permission is not mentioned. You are a senior counsel. If you mention at 2 p.m., then what example?
That's why I sought my lord. Permit me, I'll say otherwise, no, my lord. That's
Yes.
why, my lord. Item number 16, my lord, can take next Tuesday, my lord.
You can request your junior to be present instead of making a mention. Your assisting counsel can make.
That's true, my lord. That's true, my lord. That's
So you ask your assisting counsel to be present when the matter is called. See what can be done.
I'll do that, obviously.
Time being item 19.
Actually, I'm extremely sorry, lordship, when the matter was called, I should not come, lordship.
The respondents say that they have not received your papers. Why don't you submit the copy of these?
Right now, I'll serve the copy, lordship. The representation, the original, which I gave you on the last occasion, lordship. I will submit I will give you a copy of that particular.
Even a soft copy will do, my lord, and lordship will post it in the first week of my lord January, immediately after the opening. In the meantime, we will pass the speaking order.
You do it. Having heard the counsel for the parties, it is seen that there appears to be a dispute as to the receipt of the representation required to be submitted by the writ petitioner in pursuance to the directions contained in the order dated 2012-2021 passed in WPC number 2307 of 2019. In terms of the said directions of the court, the petitioner was to submit, file a fresh representation along with his proof of actual birth before the Director of Health Services within 10 days from the date of the order. Stop. According to the petitioner, the same has been furnished on?
That was on 30th of December 2021, lordship.
30th of December
2021.
Stop. The respondents, on the other hand, submit that no such copy has been received by the department. Stop. There is no record of any such representation being received. Stop. Under such circumstances, we permit the petitioner to submit a copy of the representation which he stated has been submitted to by the petitioner in pursuance to the directions contained in the order dated so and so, passed in WPC so and so. Through the council representing the state respondents. Stop. The counsel for the petitioner will ensure service of such a copy to the counsel for the respondent. And thereafter, the respondents will take all steps to comply with the directions contained in the order dated so and so, passed in WPC so and so. Accordingly, list this matter again
The reopening the lawsuit.
on
Fine,
9th,
sir. 9th.
9th of January.
Timing is one.
I want some instruction money.
পিয়ন কেইটা ক'ত গ'ল? হা? এটাতো থাকিব লাগে। মাতি দিয়ক, দুটা ফাইল কিয় যায় একেলগে? Government means, it says government has not approved.
My lord, the commissioner secretary.
Huh?
Commissioner secretary, my lord.
Who's for the respondent here?
No. M. Bhattacharya appeared.
No, but someone mentioned that government has already approved it.
They have approved, but then for budget allocation, my lord, we need their approval. So it was sent in the month of October itself. My lordship finds this reference number here in 15th October 2025.
May I submit, Lordship? Lordship, so far my understanding, Lordship, after ex post factum approval, Lordship, no separate allocation is required, Lordship. Actually, without taking the separate allocation, Lordship, there is one circular, Lordship, issued in the year 2011. Following that circular, Lordship, the department itself can pay the salary, area salary, Lordship. And that is subsequent, Lordship, proposal for allocation of fund. And 2011 circular, my learned friend Gogoi, away, Lordship, about that circular, Lordship, in one of my similar matter, Lordship. Following that, Lordship, circular, payment was made, Lordship. Normally,
But
Lordship.
this is for, unless the budget is allocated, how the amount will be released?
Lordship, no, Lordship, it is that, Lordship, for releasing the area salary, Lordship, Finance Department, Lordship, in the year 2011, issued a circular, Lordship. Normally, Lordship, budgets are sanctioned to every department in the month of March, Lordship.
No, this is for supplementary budget.
Yes, Lord.
Which means that the amount required to be sanctioned was not a part of the original budget.
Lordship, in every department, there are some surplus, Lordship. From that surplus, Lordship, Lordship.
You show us from there. So who's for the government now?
This brief was handled by Ms. M. Bhattacharya. Just notified her.
Maybe she's on election.
She was aware that we'll take up the matter at 2 p.m. You bring that circular.
Lordship. Circular number, I know, Lordship, but circular is
You
not.
take it out and give it to us. The matter was called up earlier during the course of the day. Stop. The council for Dimahasau was permitted time to obtain instructions in the matter. And the matter was fixed at 2 p.m. Subsequently, when the matter was called up, the Learned Standing Council has placed before the court written instruction received from the CDPO, Dayung Valley ICTS project, Maibang, Dimahasau, that supplementary budget prepared by the department was forwarded to the Joint Secretary Government of Assam Hills Area Department for necessary allocation and release. However, the same has not been approved. And on the sanction being granted, such pay and allowances payable to the petitioner can be released from the said fund. Who is for the Hill Area Department?
Bhattacharya was sharing.
The learned government advocate MSM Bhattacharya will obtain required instructions as to why the supplementary budget regarding the outstanding dues payable to the petitioner forwarded to the government has not been sanctioned. List. These instructions we placed before the court again on 12th December. Copy of this order be marked to the office of Senior Government Advocate for onward communication to the departments, to the Learned Council / the department. Presence record for Ilocos.
I think 11.
The show cause notice does not reflect the documents and the list of witnesses.
My lord was on as to whether did we give him any time. On 14/9/2012, my lord will see page number 67, my lord, in the writ petition. My lord, the last paragraph. Therefore, I shall submit the reply against the show cause notice dated 4/9/12 after discussion with my friends and advisors within a reasonable time. My lord, it's so vague. He did not specifically ask for 10 days, 15 days. No, my lord, it's I'm placing it before lordship. Then I'm coming to whether did you give him time, my lord. I have gone through the records, my lord. The records reveal that, my lord, on 11/9/12, we fixed, my lord, his appearance before the inquiry officer on 29/12. Then again, after this on 18/9/12, we fixed it on 21/9/12.
No. In response to this letter, did you give him a particular communication that yes, we giving you?
My lord, he submitted that letter, my lord, pursuant to the, my lord, show cause notice. Yes. We, after that, my lord, on 18/9/12, the subject is departmental inquiry. We asked him to come before the authority on 21/9/12. Meaning thereby, we gave him a time. 14/9.
This was served how?
My lord, the thing is that he was always playing hide and seek. We had to put it in this compound. We pasted it. It's written. Was my lord.
He was under suspension.
Suspension.
No.
No. He was not under suspension, my lord. He was not coming. He did not join his new place of posting. He was avoiding the office. We had to, my lord, after 3.
Is there any attendance registered? or what do you say, how do you record the presence of employees coming or not coming to a particular
My lord, he did not join his new place of posting.
in the existing place of posting?
My lord.
How many employees on a particular date are attending? Is there any?
Obvious, my lord, obvious, my lord, there has to be, my lord.
There is.
There is, my lord.
All for that. Show us that he was not attending the office in spite of
My
no
lord.
particular,
My
no
lord.
particular
My lord,
application was there.
my lord. My lord, I can.
Hmm.
So, my lord, the thing is that, yes, we gave him, my lord, the thing is that we took out a paper publication for him.
We have seen that, but you will have to place these facts that you are giving a reply and you have pasted it. Now you are saying that you have pasted it because he is not available in the office.
Office, not even in his residence.
Now, so how do you, on what, is there any attempt to serve it through a process server or peon book, or was it sent by registered post and it was returned back? We'll go through it.
My
We'll
lord,
follow up again on 9th.
My lord.
9th of December.
9th of December, my lord.
No. Is it not a good day?
No, my lord. The thing is that today is fifth. I have to get the records, this register, everything, my lord.
Get it? Where is it coming from?
No, my lord, the thing is that this
All
will
right,
be
11th.
this will be old records, my lord.
Oh.
So,
we are only giving you an opportunity to justify
my
your
lord,
statement.
my lord. I understand.
You call the officers responsible along with the records.
I will.
We are nobody to suggest, but normally, why should you take the burden of all these records? You call the competent officers, let them assist you in going through the records. Is it 9th or 11th?
11th, my lord.
11th.
Yes.
Right. List again on 11th. Matter will be treated as part of it.
Yes.
The Mr. Ardhor is permitted to call for further reports in the matter.
Yes, please, Lordship. Lordship, we have tried to communicate with them, Lordship. We have tried to communicate with the petitioner, Lordship, but we are not being able to communicate with them, Lordship.
You have tried to communicate.
Yes, Lordship.
You have not reached.
No, Lordship.
We will dismiss it.
Lordship, at least 1 week time will be granted so that we can communicate.
Counsel for the petitioner submits that in spite of attempts made, the petitioner could not be contacted. Therefore, further time is prayed for. List this matter after 4 weeks. Mr. D. Bora for the state. There's a meeting.
May it please your lordship. Day before yesterday, lordship was pleased to appoint me as the MX. My learned friend is here.
All right, we have appointed an amicus. What to do?
I'll be here.
Why, in spite of so many names, none of the councils were there?
On last occasion, my lord, I was out of the station. I could not appear.
Then again, the same question, in spite of so many councils, why none of the other councils
Other
are there?
council has already, my lord, given NOC. Therefore, I was engaged.
All right. What do you have to say here? Have you received all the papers?
Yes. I have also prepared a list of dates, my lord.
Right.
Should I hand it over, my lord?
We'll take it up in January. In terms of the earlier order, the learned amicus is available before the court, as also the counsel for the petitioner, Mr. N. Sarkar, who submits that he was out of station and therefore could not appear in the matter. This is the case of
retrospective promotion, my lord.
Retrospective promotion.
He has been given from a particular date E6 from an earlier date.
All right, then we can carry on in January. It can be listed for hearing. Again. On 20 January.
Can it be on 22nd, Manoj?
22nd only.
22nd.
22nd January.
All right.
Ms. D. Bora, appears for the respondent. Mr. C. Borua for accountant general. MS M. Bhattacharya for.
Lordship, actually, name of personal department is shown, Lordship, that's why I'm appearing. I just don't know whether.
All right, MS so appears for the personal department.
I think there will be three.
Yes. What is this matter?
Lordship, may please your Lordship. Lordship, in this writ petition, we have challenged the impugned order dated 3rd July 2017, passed by the respondent number 2, your Lordship. During the relevant period, I was the superintendent of taxes, Morigao, in charge of registration and assessment, your Lordship. Thereafter, MS Sri Maruti Traders applied for registration as dealer under AV80
This is a service matter.
Service Matter, your Lordship.
Okay.
AV80 Act 2003 and CST Act 1956, your Lordship. Thereafter,
Where is the order of dismissal?
dismissal is annexed as 11, your Lordship.
Page number?
Page number, your Lordship, 96.
No appeal file.
Lordship, thereafter, after the order was passed, your Lordship, we approached this honorable court, and during the pendency of this writ petition, a disciplinary proceeding against the petitioner has already been concluded. In respect of the show cause notice passed earlier, Lordship, show cause notice dated 25/9/2014 by the Commissioner of Taxes, who is the respondent number 3, your Lordship. Page number 49.
No, your order of dismissal is page number 96.
96.
Hmm.
A show cause notice against which a disciplinary proceedings was concluded in pendency of this writ petition, your Lordship.
Your prayer is for setting aside this order only.
Yes, your Lordship, but they have filed an affidavit in opposition, your Lordship, and in that affidavit, they have not mentioned about the disciplinary proceeding against that first show cause notice. Lordship, 2 show cause notice were issued in this
The records are available, Mr. Chaudhary.
Lordship, here I have tried to contact the authority to forward me the order, because the base 96 order is against the second show cause after serving the inquiry report,
So
Lordship.
this is what is being challenged here, 3/6/2017. That is the order they have sought for setting aside.
Yes, Lordship.
That is the order.
Yes.
There is no other prayer that earlier show cause notice was issued.
No, but from the pleadings and our reply also, Lordship, that was dropped, and again by
Subsequent show cause was
subsequent show cause was issued. An inquiry was held, inquiry report forwarded, and against that, a rejection of the second reply to the inquiry report.
Are the records available here? Disciplinary proceeding records,
No, Lordship, I will have to call for it, Lordship.
call for it. Third counsel for the parties. Rule. The matter pertains to the dismissal of the writ petition who was serving as superintendent of taxes under the Department of Finance and Taxation by initiating a disciplinary proceedings which culminated in the impugned order dated 3/6/2017. So, since the challenge is made to the order of dismissal dated so and so, in order to decide the correctness of the order, the relevant records pertaining to the departmental proceedings are required to be perused. Let accordingly issue rule, call for the records, list this matter in the month of February. First week of February. Yes.
May I please? We have provided the list of dates.
What is the dispute here?
The dispute is with regard to the alleged non-compliance because they didn't appoint because I did not follow the prescribed procedure. Prescribed procedure in the sense, your lordship may kindly come to the last letter they had issued at page 168. I'll take your lordship prior to that to the other issues. Now,
Clauses 63 and 64, where are they?
yes. The GCC,
63 and 64.
yes.
Page 75.
Yes, your lordship. Now, I had issued the claimant, the petitioner had raised the final claim before the.
So first, when the dispute arises within 120 days, you are to refer it to the jail manager.
After, no, not 120 days, but I have to, shall within, after this, the GM shall have to come to a finding after 120 days.
No, but we'll
After
have to
the
be-
disputes, before the,
Dispute will
as
have to
soon
be
as the
referred.
dispute comes, the contractor has to raise the dispute as per clause 63. And the GM, after receipt of that, shall have to communicate his reasoning or order within 120 days of receipt of that. However, there is another thing that after 120 days, as per clause 64, but within 180 days of his presenting his final claim, the contractor shall have to raise the issue of arbitration. So here what has happened, your lordships will find that the claimant, I mean to say the contractor, exercised his right under clause 63 by issuing the final claim as per annexure L, page 159, your lordship.
159, yes.
Yes. Now, on receipt of this, this was the final claim raised by the contractor, who is the petitioner before your lordship. And on May 3rd of May 24, the respondent thereafter in page 161 response to this particular letter of the claimant, petitioner, by saying that the petitioner needs to make some final adjustments with the PVC calculation and resubmit the same. They responded to that. Subsequent thereto, we submit the rectified thing as per annexure M2 at page 162 as per their request. Then, as there was no further development, then because 120 days expired, so we by annexure N1 at page 164.
Now 120 days will be counted from 159 or 162?
It should be 169 because that is the final claim. But we can go for
160?
this because after rectified thing we submitted, it can be 162, Your Lordship.
All
So
right, then.
thereafter, within 180 days, thereafter, we raised the final demand for arbitration.
164.
Yes, Your Lordship.
That has not been answered.
That has been answered, Your Lordship. They answered it, Your Lordship may come to annexure 168. Here what they say is that they refer to my invocation of arbitration. They say that it is mentioned you have submitted one notice under section 11 of the Arbitration and Conciliation Act for the appointment of arbitrator. As per contract agreement, there are clauses for arbitration, clause 63 and 64. But in the instant case, you have submitted notice under 11 instead of 63 and 64. So my demand has been rejected. Now, because in my application, I did not specifically say with regard to 63, but the spirit was there with regard to that we want to go for arbitration. Now, my learned colleague has taken up another plea which was not raised earlier during the correspondent exchange between the parties. They have tried to portray a thing that I have not complied with the requirement of section 60, clause 63. Because their contention is that I did not approach the GM. That is, I approached the chief engineer who had signed the contract.
Yes.
That was their contention. But it was not rejected. They responded to it. That was my argument before Your Lordship on the earlier occasion.
Yes, Mr. Gupta.
Well,
Now we'll have to think of mediation prior to arbitration.
No.
Why are you objecting?
Well, because
These are technical objections.
the agreed procedure, my lord, for the appointment.
Agreed procedure has
That
been
has
violated
to
by
be
you
followed by the-
also.
No, my lord, we are only.
If the claims are to be raised only before the GM, how can the chief engineer, deputy chief engineer ask them to rectify their bill? What authority? What action have you taken against their officers?
That is why, my lord, the initiation itself is
No, but
wrong.
why are you penalizing only the petitioner? Why not your officers? How can they step into the shoes of the general manager if it is only the general manager who has to be addressed and who can give
No, that,
his views?
Lord, that is why that problem, my lord. If the application would have been under 63, if they would have my lord, if the chief engineer would have addressed the application under 63, clause 63, then it would have been without jurisdiction. There is no clarification, my lord, when the petitioner makes a representation, he has not made representation under clause 63. If you would have represented under
You
clause
have
63.
entered into a contract where these clauses are there. The general manager or the chief engineer is not supposed to give reply to each and every letter. It has reference to a particular contract. Is he not supposed to say that your letter is not required to be addressed because it doesn't follow the requirements
So
of
those letters may not be, my lord, under clause 63. That may be relating to non-payment of bills, whether it is relating to a dispute
No,
which the parties are intending to go for arbitration.
To which contract?
present contract, my lord,
Yeah.
that is relating to the bills.
Then
That may not be the dispute. If the intention of the party
Hmm.
was to raise a dispute under arbitration, then clause 63 ought to have been invoked. These letters dated 159, my lord, that is regarding final claim. They are asking for final bill only. There is no dispute here that they want to get in dispute adjudicated or they are agreed by some non-payment. They are just asking for the final bill. To that we have replied, my lord, that PVC will be recalculated. They have not said that we have a dispute and therefore we want to go under clause 63. There is no such averment, my lord, in paragraph 1, page 159 representation. They are only asking the department
kindly,
is.
kindly come to page number 159 at the last paragraph.
Last paragraph, Munir. Department by not releasing our final bill, final PVC and non-release of security deposit has compelled us to get into litigation for getting our above mentioned legitimate dues. We are left with no other alternative but to mention our claims for payment
What is
again.
this? What is the tenor of this language if it is not dispute?
That is only regard to the final bill, my lord.
That's right.
Because that calculations will be made, but here now when the dispute is raised, other issues are also raised, my lord, regarding non-submission of neutralization of GST and illogically hold loss and damages, other
You
things
take
are
up
also
all these
claimed.
You take up all these claims before the amount raised is the same amount, isn't it?
Yes, it is the same.
1 crore 17 lakhs.
Yes, your lordship.
It's the same amount.
1 crore 17 lakhs.
The same figures are there. Your lordship.
Same amount.
My lord, then our only submission is, my lord, the procedure has to be followed.
It has been followed.
Clause 63, there was no representation made before the GM. And, my lord, they directly approached under that too not mentioned, my lord, under clause 64, they ought to have.
You are raising technical issues which are of only to resort to dilatory tactics. That's all. What is this? This is a contract. You have entered into it. You have agreed that in case of a dispute, we will refer it to arbitration.
But
If
these
your
contractors
officers are
very well know,
incompetent,
my lord, they are
if
very
your
old
officers are
contractors.
unable to read between the lines that it is, if it is anything but a dispute, merely because the reference of a clause is not made, will it be sufficient to throw it out?
Not be, my lord.
Then
But they have to.
are you agreed on an arbitrator?
From the list, my lord, can.
All right, heard, Mr. A. Biswar.
Anyone your lordship may appoint on the list.
For the petitioner. And we have the list here.
Yes, sir.
Mr. H. Gupta, learner CGC appearing for the railways. The petitioner is
Yes, sir. Lordship, is,
allow us to pass the order first.
yes, sir.
The is a private limited company incorporated under the Companies Act 1956, having its registered office in Guwahati, Riyabari, Guwahati. Stop. The petitioner is engaged in various civil works, constructions under various state and central departments, including the railways. In the present writ petition, the writ petitioners, the petitioners are represented by the director, one of its director, who is duly authorized. Stop. The petitioner was awarded a contract for construction of so-and-so, paragraph number 3, underlined portion, by the railway stop. A contract agreement was entered by and between the parties, entered and executed on 12th of April 2013. Stop. Did you complete the work or it was
Yes,
terminated?
final completion certificate is also there.
The work was duly completed by the petitioner and the final completion certificate was also issued.
Annexure B, page 142. Actual date of
31/10/2015.
completion is 39 2015.
issued by the Deputy Chief Engineer / CON / IV / SCL. Page number 142. Stop. The said certificate reflects that physical progress of 100% work has been completed and part payment has already been made and the final bill is under process. So after the execution of the contract, according to the petitioner, certain disputes have arisen. And accordingly, a communication was issued to the Chief Engineer / CON / Roman 1 capital, making a final claim relating to the final claim amount of 1,17,39,847 arising out of the so-and-so contract. Stop. The final claim raised by the petitioners have been reflected in the said communication with the has been raised in the said communication. Stop. There are as many as 6 different claims under the claims of the petitioners have been shown under 6 different heads. Stop. Pursuant to the said communication dated so-and-so, the railways informed the petitioner by communication dated 18/6/24, whereby their final PVC bill was returned for recalculation as per clause 40.5 of the contract agreement. So this rectified PVC bill was again subsequently submitted on June 24th, 2024. Well, however, since these claims were not redressed, the petitioner issued a notice under the provisions of Arbitration and Conciliation Act 1996 by the notice dated 5th of October 2027, calling upon the respondents to issued a notice under the provisions of the Arbitration and Conciliation Act. Stop. This was replied to by the Deputy Chief Engineer / CON / HQ by communication dated 23/1/2025 that this notice could not have been issued without first resorting to the clauses 63 and 64 of the general conditions of contract in the said agreement. So under such circumstances, the the petition number 11.6 has been filed. Stop. Learned Counsel for the petitioner submits that the petitioners have approached this court under Section 11 of the Arbitration and Conciliation Act in as much as that in spite of notices being issued, in spite of disputes having arisen and the notices having been issued, the respondents have failed to refer the matter to arbitration. And therefore, this application is filed for appointment of an arbitrator and referring the dispute to be resolved by appointment of a sole arbitrator. Per contra, Mr. H. Gupta, learned CGC, on the other hand, disputes the contentions raised by the petitioner. The respondents have contested the matter by filing their affidavits. In the affidavit, the respondents have raised the contention that the provisions under Section 63 and 64 of the GCC has not been followed by the petitioner. And therefore, the was premature to refer the matter to arbitration. And as a consequence thereof, this petition under Section 11.6 is premature at this stage and should therefore be rejected, relegating the petitioner to resort to the provisions prescribed under clauses 63, 64 of the GCC. Learned Counsel for the parties have been heard. Readings available on record have been perused. The clause 63 and 64(1) reads as under extract page 75. A perusal of these clauses reveal that when disputes or differences of any kind arising out of or in connection with the contract arises out of or in connection with the contract, whether during the progress of the work or in completion, after completion, then they shall be referred by the contractor to the general manager, and the general manager shall within 120 days after receipt of the contractor's representation make and notify decisions on all matters referred to by the contractor in writing, provided that matters for which provisions shall be all matters referred to by the contractor in writing. If after 120 days, the general manager has not been able to resolve the disputes, then the matter has to be referred and then the contractor shall, after 120 days, but within 180 days of his presenting his final claim on the disputed matters, shall demand in writing that the dispute or difference be referred to arbitration. The petitioner had initially, there is no dispute that the contract work exercised has been, contract work allotted to the petitioner has been executed, and completion certificate has also been issued by the employer railways. So by the communication dated 3rd of March 2024, the petitioner has raised the dispute to the chief engineer. Stop. The claims raised amount under 6 different claim heads amount to a total of 1,17,39,847. Stop. This was replied to by the respondent railway by communication dated 18/6/2024, requesting for recalculation of the PVC bill. Stop. This rectified PVC bill again came to be submitted on June 24th, 2024. Stop. As such, if under provision 63, clause 63, the 120 days is to be calculated, then the same with effect from June 24th of 2024, the same expires on so and so date. In terms of clause 63 read with 64, once the railways fail to resolve the dispute, then the contractor is required to raise a demand for arbitration under section 11 of the Arbitration and Conciliation Act. Where does one find the contract data?
Contract data, your lordship will see. Data for- Contract data, अलग-अलग एक page data.
So the objection raised by the railways that under 63, 64, clauses 63, 64, the contractor is to raise the dispute and refer it to the GM has not been complied with, needs to be examined. Stop. By communication dated 3rd of May 2024, it is seen that the same was addressed to the chief engineer, and which was replied to by the deputy chief engineer by the communication dated 18/6/2024, requiring the contractor petitioner to submit rectified PVC bill. Stop. This rectified PVC bill came to be submitted on June 24th, 2024 by the to the deputy chief engineer contracts-Roman 2. Stop. A plain reading of the communication dated 3rd of May 24 as well as the 24th June 2024 reflects that the contractor petitioner has ventilated his grievance for non-releasing his final bill, final PVC bill, non-release of security deposits, whereby they have been compelled to get into litigation for getting their legitimate dues. Stop. Therefore, the tenor of these two communications clearly reveal that the petitioners are aggrieved by non-release of their final bills and other dues specified in the said communication. Stop. This, in the opinion of the court, is a clear indication that the petitioners have raised a dispute or non-release of the dues. Stop. The objection raised by the respondents that there is no specific demand, that there is no specific reference to the term within quotes dispute or differences in the said communication, and therefore it cannot be considered to be it cannot be considered to be a dispute arising under clause 63, read with clause 64, cannot be accepted. So, the objection raised by the railways is essentially to the form of the communication issue and not to the intention of the parties. So, similar objection is raised to the communication dated 5th of October 2024, under which the petitioners had issued a notice under Section 11 of Arbitration and Conciliation Act 1996. So, the objection raised by the railways is that this is not a notice contemplated under the provisions of Arbitration and Conciliation Act 1996, as the notice is contemplated under Section 21 and not under Section 11. But this objection, the railways also has to be overruled, in as much as the wrong quotation of a section cannot be used to throw out the claims of the contractor when the reading of when the tenor of the said notice reflects clearly that the contractor has raised his disputes and has under the provisions of Article Arbitration and Conciliation Act 1996. So, better. It is no longer res integra that the referral court's jurisdiction is primarily to inspect the existence of a valid arbitration agreement. So, in the facts and circumstances of the case, there is no dispute that the agreement executed by and between the parties, ID, agreement number so and so, does contain an arbitration clause in the event of any disputes arising by and between the parties. So, In fact, on the clause 45 of the said contract, there is a clear indication that settlement of disputes shall be governed by arbitration by the clauses 63, 64 of the GCC. Stop. The submission of the claims by the petitioner by the communication dated that by May 3rd, 2024, having been addressed May 3rd, 2024, and the subsequent rectified or revised PVC bill dated June 24, 2024, having been addressed to the chief engineer / construction / 1, Roman 1, and deputy chief engineer / construction - Roman 2, cannot be faulted with as being violative of the provisions of clause 63, that the same ought to have been addressed to the GM, inasmuch as it was available to the concerned officers to refer these matters to the general manager, if so required. However, pursuant to the first communication dated 3rd of May 2024, the chief engineer construction chose to reply to the petitioner requesting them for filing revised PVC bill. So, that apart, the contract agreement itself was signed and executed by the deputy chief engineer construction. The agreement on behalf of the railways was executed by the deputy chief engineer /C /tender on 12/4/2013. Therefore, the court is of the view that under the circumstances, the prescriptions under clause 63 has been substantially complied with, and the same not having yielded any results towards settlement of the disputes, the matter it was required to be referred to arbitration on the basis of the communication dated Fifth of October 2024. So, in the principles governing the scope of inquiry by the referral court in matters of arbitration has been restated in the judgment of the apex court in SBI General Insurance versus so and so, reported insurance, as well as OT Technologies reported in so and so. After a careful perusal of these parameters set by the apex court, which is binding on all high courts, including this court, it is held that there exists a valid arbitration agreement between the parties, wherein agreed that in the event of any disputes if disputes and differences arising by and between the parties, the matter has to be referred to arbitration. Is there one sole arbitrator or more?
This is sole.
Where is it referred?
Breakup.
Hmm? Any provisions of the contract?
Yes, sir. वो जो quantification किया हुआ falls within page 76 मतलब
Clause number?
64 3A1 and clause 64 3A2. More than 10 lakhs मतलब it will be 3. When it is 3 arbitrators. अपना को 3 होगा. Oh, it would be 3 arbitrators then, your lord. When that
Of
case
the claims
64 3A1.
in case last line. In case of any disputes, the matter is to be resorted to arbitration in terms of clause 64(3) within bracket
A1.
bracket close bracket Roman 1 and 64(3) Roman 2. Stop. Where the dispute, where the total value of all claims does not exceed rupees 10 lakhs, the arbitral tribunal, as per clause 63(a)(1), where the total value of all the claims does not exceed rupees 10 lakhs, then the arbitral tribunal shall consist of a sole arbitrator. Stop. Where the cases are not covered under 64, that under clause 64(3)(a)(2), it is specified that in cases it is not covered under 64(3)(a)(1), the arbitral tribunal shall consist of 3 gazetted railway officers not below the JA grade or 2 railway gazetted officers not below JA grade and a retired railway officer not below the rank of SAG officer as arbitrators. So, therefore, since the claims raised by the petitioner exceed more than 10 crores, 10 lakhs, the provisions of clause 64(3)(a)(2) is applicable, subject to such subject to the directions of the apex court in
2025
the
4
parameters
SCC 64.
reported parameters laid down in
It was a 2025 4 SCC page 641.
what is the name of the party?
4 Central Organization for Railway Electrical versus
Judgment.
ECI.
2025
2025 4 SCC 641, the latest allotted.
641.
Para 170 is the
Paragraph so and so. Where the court has held that apex court, constitutional bench of the apex court has held that in view of the amendments brought to the Arbitration Act under section 12(5), where the contractor does not consent to appointment of curated arbitrators from the panel of the no, appointment of arbitrators from the curated panel of the authorities, comma, the railways in the present case, comma. Then the referral court will have jurisdiction to appoint. Then the referral court will have no option but to appoint arbitrators. In the facts of the present case and considering the submissions raised, the counsel appearing for the writ petitioner submits that they have not waived their right permitting the railways to appoint arbitrators from the curated panel maintained. So, under such circumstances, under the provisions of the powers conferred under Section 11 of the Arbitration and Conciliation Act 1996, this court therefore appoints
Mrinmoy Kumar Bhattacharjee, retired district judge.
Mrinmoy Kumar Bhattacharjee,
Number 10.
retired district and session judge, as the arbitrator on behalf of the writ petitioner, and Mr.
Expert.
The second name available?
Second name Pradeep Kumar Das or
My lord, technical expert can be given, my lord. No, three persons will be, or any technical person,
any technical person.
Vanikanta Das, Ajay Kumar Chandra Bodolai.
Yes.
Ajay Chandra Bodolai, my lord, can be.
Sri Ajay Chandra Bodolai. From the panel of arbitrators notified by the Guwahati High Court by notification dated notification number 29 dated 21st of May 2024. Stop. The two arbitrators appointed shall be notified by the registry of the court, and certified copies of these orders may also be placed before them by the respective parties. Stop. These arbitrators appointed by the order of the court today shall give written declaration under Section 12(1)
Yes, sir.
before the registry within by the next date fixed. Depending on these written declaration as may be received by the registry, we place before this court the appointments made to the prospective arbitrators shall be confirmed. So once the appointments of the prospective arbitrators are confirmed, they will be at liberty to appoint an umpire. So list again on 17th or later.
Any date, your lord. Or 17th January.
No,
After that,
17th
your
December.
lordship.
Yes,
You can have. 17th.
17th December?
No,
Or you want it in January?
No, December.
17th December.
no.
17th December.
My lord, the SBI General Insurance citation, my lord, may I give, my lord? SBI General Insurance, my lord, which is Chris Spinning Judgment. That citation, my lord, I will just indicate, my lord. My lord has mentioned the judgment, the citation, my lord, may I give?
Yes, of course.
My lord, 2024 12 SCC 1.
2024
12 SCC 1.
Page 1. Highly obliged.
With the Goki technology release. Our judgment to defense. Yes, good.
Days for hearing, August 15.
In this case, argument is over, Your Lordship. Your Lordship will remember, this is a case of Paritian penalty. Because a coordinate bench judgment, I relied upon a coordinate bench judgment. All the co-accused, Your Lordship, were retained either by giving the punishment of compulsory retirement or punishment of reduction of increments, Your Lordship. And same charge, my lord, exactly same charge, following the judgment of Rajendra Kumar Jadhav, Your Lordship. That judgment, this honorable court, in a coordinate bench judgment, exactly, charge is also quoted in the judgment itself, Your Lordship. Judgment itself. And only he is the, now, my lord, others, chart was given.
You give us gist of your synopsis along with the judgments you are relying on. Right. Is there any other judgment you are relying on?
Yes, now, my lord, Your Lordship, after Your Lordship instructed me to find out any other judgments. The Rajendra Kumar judgment and our coordinate bench, similar judgment have been passed by Madras High Court, Telangana High Court.
Give us a list.
My lord, that judgment, I have brought a
asked
list of
your-
judgments, my lord.
No,
And
you give us a
FCC
list.
person is better, my lord. Rajendra judgment,
Give us a list of the judgments.
I have brought the judgments.
Judgments will very well, but you give us a list of the judgments you are
Real
relying.
list of the judgment is there.
All right. So your your ground is, primary ground is that once a coordinate bench has-
All are retained, everyone. Everyone are retained.
except
And
for the-
same charge. And all are modified. A removal order was passed in favor of the my lord, other co-accused, then it was modified. And chart is given, Lordship will find, for a moment, if Your Lordship take up the judgment of this coordinate bench, there Your Lordship will find.
No, we have gone through that. We
They are-
wanted to know, is there anything else you want to submit?
My lord, absolutely covered by the coordinate bench judgment, the Rajendra Kumar judgment, Supreme Court, that was followed. And Madras High Court also followed the same judgment. Telangana High Court also followed the same judgment. They even accept, my lord, accept the petitioner. Now all either got relief from the court or department has itself. And some of the accused, my lord, are not given, only reprimanded. And minor penalties were given.
In respect of the judgment that you referred to, given by this court.
Same charge, my lord, same charge.
I know, but that is with regard to only one person.
Only one person.
How many persons were charged?
8 persons.
8.
And one person, my lord, who is the main in charge, he was reprimanded on account of his retirement.
What happened to the other?
Others were given minor, my lordship will look into other minor penalties of lordship will look into annexure 12, 13 and 14 of my writ petition, Your Lordship. 12, 13 and 14. 85, Lordship. Page 85, Your Lordship.
Yes.
ABSI Majuddin Mandal. I am a constable, my lord. In the bottom, Your Lordship may straightway come to the bottom, my lord, order. In the bottom, from the middle, my lord.
Yes.
It is therefore ex-SBI Majuddin Mandal is not in any way associated in the scandal, but he cannot escape from the responsibility of the ignorance about the whole matter. Having regard to the long service career on application of mind and natural justice, I found punishment inflicted on the officer by the disciplinary authority is disproportionate than his offense. I am of the considerate view that dismissal is not justified. The appellant has neither conspired with anyone nor had any intention of misappropriating of any government money, and as such, finding of the inquiry officer is erroneous. I therefore take a lenient view and set aside the and quashed the dismissal order of the commandant at the April Battalion 27/9/2025 and passed the following orders. FCI Majuddin 8th Battalion should reinstated in service. Order stoppage of 2 annual increment without cumulative effect. The suspension order may be treated as on duty for all purposes. The period with effect from 27/9/2015 from the date of removal to the date of his reinstatement may be treated as on the principle of no work, thereby no pay. My lord, similar order have been passed. Ashok Kumar Bora, page 87, Your Lordship.
page 87. Page 87. Page 87, your lordship will find.
Yes.
And my lord, only one thing, my lord, I'll show that in the coordinate by judgment, only it is specifically stated, my lord, hold that except the variation of quantum of money, these charges are same. Charges are same in the coordinate by judgment para, and charge was quoted. A statement of allegation were quoted in the judgment, your lordship, and lordship will find that is in my lordship page 162.
Yes.
Your lordship will find the modified orders who were given removal. Page 27. 162, sorry, my lord. 162.
Petitioner was awarded what term in dismissal?
Dismissal. Others also awarded dismissal, but my lord, modified by the appellate authorities. And one case.
Petitioner's order was not modified.
Not modified. Lordship, page 162. Lordship will find the list in the judgment. It is list is quoted, your lordship. In the judgment of this coordinate bench. Coordinate bench judgment, the allegation is quoted. Judgment is started from page 152, my lord. 151.
Yes.
And para 2, your lordship. Para 3, your lordship, 153. The charge was quoted. The same charge, your lordship. Charge was quoted in page 153, your lordship. In the bottom, my lord, the charge against the petitioner was as follows. And then, my lord, there are 154 also. The amount was shown. And lordship will find the chart, your lordship, page 162. The orders of removal have been modified by the appellate authority.
162 page and 162 page. Case law to be.
It is quoted in judgment itself, my coordinate bench judgment.
Yes.
The Majuddin Mandal removal, my lord, it was reinstated in service. It is modified. Then Ashok Kumar Bora removed from service.
We have heard this post.
My lord, deeply obliged.
I have two cases, my lord. Let's continue. I have two cases, my lord, regarding, my lord, interference of this honorable court. Ultimately, my lord, Supreme Court says it demand back to the authority in the case of the Perity case, my lord. I am reading and few about, my lord. The 2019 15 SCC 51. First case, my lord. State of Tamil Nadu. Paragraph 14 and 15 is important, my lord. While deciding such a submission was in the fact made before a single judge, the division bench proceeded to apply the yardstick of Perity. Perity could not be applied for the simple reason that there was a materialization in the case of the misconduct alleged against the appellants as compared to the other employees. While the language of the charge may be similar in other cases, that did not detract from the fact that the amount involved and the extent of lack of verification in the case of the respondent was much higher than other. The division bench having noticed that
in respect of the other coordinate bench order, any appeal? Any appeal filed?
I don't know, my lord.
Check up and tell us.
But this is a Supreme Court judgment, my lord. This says.
We are asking you in respect of the coordinate bench whether any appeal has been filed.
My lord,
You check up and tell us.
Court bench of court was the judgment. This is.
Yes, Achut Kolita. So for my instruction, my lord, goes, no appeal is better. And my lord, there was the judgment of this honorable High Court of His Lordship Justice Rishikesh Roy judgment, that also I'll pass. This is same, exactly on the same point.
But why have you not included in the list?
My lord, that now my friend has pointed.
So you prepare and include in the list. Don't give us piecemeal. Either you really rely or you don't rely. You want to rely, then include in the list.
My lord,
Ask him to include in the list. Otherwise, it gets misplaced. That's the reason.
only now my friend has shown that this honorable court got another judgment, my lord, on the same point, exactly.
All right. You write it and give it to us.
My lord, I'll write out.
That was the discussed in the Supreme Court, my lord. Not the nature of the same, but gravity of the, my lord, offense involved is to be counted. That's why Supreme Court said.
We'll keep it on 16th for orders. 16th
Right.
December for orders.
I have submitted 2 cases.
My lord, I'll include it by hand, man. I'll include it by hand. Obliged, your lordship, deeply obliged.
Lord, our submission and the case law has already been submitted before this honorable court.
Some gazette notification you are required to give.
Actually, my senior has advised that nothing is required to be submitted today.
All right. The list on 16th for orders. 16 December.
May please, Lordship, my lord, this matter can it be taken up on Tuesday, my lord?
Tuesday. All right, Tuesday.
My lord,
Nine.
otherwise we have some urgency, my lord.
Tuesday? You wanted it on Tuesday?
Yes, my lord, yes, my lord.
Yes, Tuesday.
Yes, my lord. Obliged, my
The
lord.
request of counsel for the petitioner list on Tuesday.
Obliged, my lord.
Next.
Item 17 and 18.
17 and 18, my lord, are essentially the same case, my lord. 18 is the
If I may, Lordship,
comprehensive one.
point out something before my learned friend starts, Lordship. This matter, it was kept as CAB for a long time, and we submitted the original records, it was detained by the Honorable Court. Now, Lordship will kindly see Lordship order on 18/9/2024. The records somehow, the original records that we have submitted somehow are missing, not found. My lord directed the registry to produce the records, but office note. There's an office note on 15/10/2025.
There is no record of the records being received.
Now, Lordship, you kindly see that order dated 19/3/2024. 19/3/2024. It clearly shows the records were submitted and retained by the Honorable Court. And
Tell us what is to be done now.
sometime we given, I'll see, ask them to proceed.
For my purpose, my lord, those records are not necessary. I made myself clear last time also. Because the records that were wanted relating to the creation of the post, because they took a ground that it was a newly sanctioned post. So the court wanted, give us the details, how you have sanctioned, how it has gone to the finance committee and all that. The records they had produced was relating to the DPC, my lord. So that is not necessary. I can do it, but for their purpose, my lord, I do not know official purpose. For the purpose of the case,
This is, you are challenging, what are you challenging here?
my lord, I am challenging the appointment of the respondent number 7, right, my lord, I'm seeking a direction for my appointment as per my selection in the wait list,
For which post?
for the post of assistant registrar in the respondent IIT. Man. My lord, issue is like this, my lord. If it is not a newly sanctioned post, my lord, then under the law, my lord,
Which respondent?
respondent number 7 has been appointed, my lord.
Respondent 7.
Yes, ma'am. Your lordship, kindly take up the petition number 3937. 3937, that is a comprehensive one. ma'am.
3937.
Yes, ma'am. 202.
Who represents respondent 7?
Mr. Mohanto. Oh,
You are appearing.
I was appointed in the year 20. Serving issue.
Actually, this matter was hard, my lord, some time back, and then.
That we have found out.
Yes,
Yes.
yes.
You also submitted the written arguments also in this matter. All are.
No, but then you'll have to re-argue the matter.
Yes, yes, well, I'm reading.
Huh?
One minute.
Yes. My lord, the petitioner, my
If
lord.
the records are necessary, we'll do something.
Yes,
But
yes,
Let us
maybe
understand
Yes,
what
it
is
will
the
be
matter.
necessary, lordship,
Yes.
that sanction part and all these things.
Yes.
Sometimes we are giving them by, we'll ask them to reconstruct the records.
My lord, that
That will be-
opportunity was given to them long back, my lord.
No,
Several
it
times.
is only, it has come in
Time.
only October, yeah. The note has come that they have not found the record.
No, these records are not necessary for the purpose of the petitioner, my lord. That I'm making
Or
myself
to
clear.
be in the safe side, lordship, the records will be necessary, which lordship also may require records.
So
So
what
given-
do the records contain?
Lordship,
What are the records relevant for?
my
What do the records contain?
records relating to the lordship, firstly, selection process. Secondly, the wait list with controversy is being created, he's being the first man of the wait list. Whether that sanction is there, with the second advertisement, which is a new post.
How many posts were there?
One post, my lord.
One post,
One post.
unreserved category.
Unreserved category.
And this is a direct recruitment.
This is an internal, they say internal appointment, other promotion. ma'am.
By promotion.
By promotion.
So
Meanwhile, respondent number 7 has been selected and appointed. He is holding the post. For all these,
But
lordship,
the records that were produced, my lord, those were perused by the court at the relevant time, and those are not relevant, my lord. The court expressed itself,
no,
saying that,
no,
right?
let us understand
Yes,
what is what is the list here? You are
list here is
challenging
this,
the
ma'am.
appointment of respondent number 7.
Respondent number 7,
Hmm.
which post should have been given to me by virtue of my selection
Hmm.
and my placement in the top of the wait list. What happens?
Respondent 7 was not there in the select list.
Not there, man. He came later, subsequently. ma'am.
subsequent advertisement.
My lord, let me, my lord,
Oh, sure, please, sir.
please, kindly
Thank you,
allow
thank
me to
Sorry.
submit. My lord, there is this procedure, my lord, of appointment, my lord. If one is appointed, if a selection is made, man, if a DPC is held for a particular post, my lord, in within a year, man, then, my lord, a wait list is also prepared. Now, my lord, if additional vacancy subsequently arises within that year, or that is called a vacancy year, which it is, my lord, co-terminus with the normal year, my lord, 31st December. So within that year, if another vacancy comes, as per the law, my lord, since the selection procedure, my lord, the qualification does not change, my lord. I'll place all that, my lord, so that to the vacant post, subsequently, that arose subsequently, man, that is filled up by the person at the top of the wait list. For that, a new DPC is not necessary to be held. That is the law. Here, what has happened?
This is the prescription under what?
Under Department of, my lord, it is, I have given guidelines, my lord, DOPT guidelines.
Where is that?
I annexed it, Annexure 4, my lord, page 35.
I beg your pardon, lordship. If I may point out, Lordship, just for one thing, the DOPT is not followed by us. We have our own rules.
What does your rule say?
No,
My friend will get his opportunity, man. Let me finish my.
sure.
Page number 37.
Yes, ma'am. Your Lordship will see one, this will be for. At D, my lord. This is 4.4.9.
37.
1D, man. Page 57. The officers who have already been empaneled or placed in the extended panel. Extended panel, in other words, is a wait list. But could not be promoted due to these vacancies not actually becoming available, need not be reassessed by the supplementary DPC as the assessment matrix remains the same. But they cannot change the criteria that for that year, my lord, the qualification remains the same. And qualification as on 1st of January of that particular year. They may be appointed against the additional vacancy of same vacancy as per recommendation of the earlier DPC. In such a number of vacancies for supplement DPC. This is my case. Now, what has happened in this case, my lord? If your lordship kindly comes to.
Is there no particular time limit?
Yes, it's 1 year.
1 year.
Yeah, 1 year.
So the officers who have been empaneled and placed in the extended panel, which is the waiting list.
Yes, my lord.
Who could not be promoted due to the vacancies not becoming actually available, are entitled to be promoted upon the vacancies being available.
Available if within that particular vacancy year or till 31st of December.
Okay.
Now, my lord, my position in the election. My lord, the first that circular is at page 27, 512022, whereby the post was advertised. It's 27. Thank you, Lordship. My lord, the name of the post is given, my lord, at serial 1, assistant registrar. Then, my lord, eligibility criteria. There is no dispute relating to this thing, my lord. What is important is this, my lord. General information below. Number 1, cutoff date for counting experience is 1/1/2022. And the DOPT rules also, my lord, lay down clearly that the qualification as on the 1st of January of that particular year. This I am pointing out for the very fact that they had argued a point they have taken. That change that the subsequently since the eligibility criteria has been changed, so therefore they had to, my lord, go for a fresh DPC. So that they cannot do at all. Now, my lord, at serial 3, below that, man.
Yes.
The panel selection or waiting list drawn up by the Departmental Promotion Committee DPC as per Government of India norms would be valid for 1 year. So this result of the DPC will be valid for 1 year. If any post falls vacant within 1 year of the DPC meeting, the same will be filled using the waiting list as per category. So since I was at the top of the wait list, I should have been appointed to the subsequently, my lord, vacant post. This is the case, man. And this will, next line is important. This will not apply for fresh sanction of post made after advertisement. Candidates will be selected as per recommended list. This is another ground. They had taken essentially these two grounds. In the preliminary affidavit they filed in the first writ petition, my lord, they made themselves clear that the provision of Rule 3 will not be applicable because of this, my lord, provision that it was a newly sanctioned post. That was their stand. Then, my lord, I filed the second case, my lord, because during the pendency of the first writ petition, the promotion was of the respondent number 7 was approved. And so I had to challenge it. Initially, I didn't challenge it. I claim on the basis of my right in this, by virtue of the my selection in the wait list. Now, my lord, Annexure 2, the DPC results. Page 29, it starts. The board was requested to approve the recommendation of selection committee for the above mentioned post. Board resolved as under. Then there, my lord, the selection committee is given, and the committee noted that 17 internal candidates had applied for the post of assistant registrar. After screening the application, all the following 70 candidates were called for the interview. The name of the petitioner is here at serial 17. Then the next page, page 30. Page 39 meeting, my lord. The board was requested to approve the recommendation of the selection committee. The recommendation of the committee was opened before the BOG and the names were read aloud. The board was requested to consider and approve the selection committee report that recommended the following 4 candidates for the post of assistant registrar, unreserved by DPC meeting held on 18/2/2002. So these are the names: Jivan Chandra Burman, Niva Devi, Ritu Purna Sharma, Jiten. My lord, they were selected, they were appointed. Then the committee also recommended the following panel, valid for 1 year. At the top of the list, your lordship will find the name of the petitioner. Serial 5, Surendra Mohan Khaloi, as per rules. Then below that, resolved to approve the recommendation of the Department Promotion Committee meeting for selection of the 4 candidates and the panel mentioned above for the post of assistant registrar held on 18/2/2002. Then, my lord, now this piece of information, this select list was neither communicated to me nor put up in their official portal, my lord, or the IIT website, my lord. That, my lord, I had given the in the first week, December. No? They did not, my lord, post that in their website. So this knowledge was, information was held back from me, my lord. That I have annexed at annexure. Page 49, annexure 8. There is no mention of this Board of Governors meeting and the DPC, my lord. Approval and the DPC.
49.
Page 49. So that information was held back. Now, subsequently, my lord, another post fell vacant. That's what they say, my lord. And they came out with the second advertisement.
Then?
Okay. So that information was held back, my lord. Waitlist was not published, nor it was put up in their IIT portal, the website. Therefore, my lord, when the next post fell vacant, they came out with a circular on 12/12/2022, December. But at serial 1, assistant registrar, 1 post. And I applied.
So you're referring to which page?
Page 31, I'm sorry.
31.
Page 31.
Yes.
This IIT Guwahati inviting online application forms from eligible internal candidates for the following posts. Assistant Registrar 1. So I again applied. I did not know that I was already placed at the top of the wait list. Then you will see page 33. And again, showing, my lord, this cutoff date for counting experience is 1/1/2022. So qualification remain the same. Then, my lord, the guidelines. BOPT, I had just taken your lordship.
Now, during the pendency of that process, I came to learn that I already stood selected and my name was at the top of the wait list of the last interview of 18 to 2022. So I represented page 38, Annexa 5. On 24/5/2023, immediately on my knowledge, which I submitted by this representation. And thereafter, I had represented again, my lord, on 31/5/2023, this time to the director officiating man. Because first time when I had represented before register, they said this is not the proper procedure. You should have applied to the director officiating man. At that time, it was officiating to the director. So I represented before the director also as requirement. But
you also applied for the second.
Yes, ma'am. Because it was that information was held that wait list was never published. And there is no denial. And that they did not put it up in the official website, IIT website. There is no denial. My lord, on the contrary, my lord,
No.
I invited their
The second interview.
Yes.
How many posts were?
One.
One post. And the earlier advertisement also one post.
Four posts.
Four posts.
Four posts. 4 posts were, they were from the main list, they were appointed. The names I had just shown.
They were 4 posts were filled up.
Filled up.
Then what was the benefit of keeping you in wait list? I mean, your claims against which post?
I was in the wait list for those 4 posts, my lord. They had kept it, my lord. The provision is here, my lord. If that within that vacancy year, if a subsequent vacancy arises, then they bring from that. They do not hold a fresh DPC, my lord.
Where is that? Where is that guideline?
Page 40. No, yes. My lord, page 35. The
37.
relevant is 37. D, man. This is clause 4.4.9.
No, this is something different. This is who were empaneled.
Yes.
But who could not be promoted due to the vacancies.
No, empaneled or placed in the extended panel.
That's right. Extended panel.
Yes.
That is the wait list. But you could not be promoted due to these vacancies actually not becoming available.
Because, my lord, I had placed, my lord, at page number 40. My lord, this is the procedure, my lord. In there, my lord, this procedure is followed by them, my lord.
When did the vacancy, subsequent vacancy become available?
In December.
And when was the select list declared?
My lord, first one, my lord, 18/2. 18/2/22, and this the second circular is 12/12/22. Your lordship, kindly come to page 41, my lord.
So
Page 40.
from the wait list, you are the only person who again applied.
Yes, man. I was at the top, my lord. It happened
all right.
at the top. Not otherwise.
Any other person did they apply?
Other persons applied, my lord. Even the respondent number 7 applied, and some others applied. 17 people applied in all.
All right. So what do the rules of IIT say?
They don't have any recruitment rules as such relating to this, my lord. My senior friend will definitely submit, my lord. But they follow these guidelines, man, which are applicable to them. And my lord, page 40, if your lordship comes, page 40 will show that how they fill the senior superintendent from the panel, wait list panel, man. This extended panel or wait list, my lord. Page 40. I have marked Mr. Lolit Soikia, Supriya Das, Rajiv Losun Gogoi, Leonie Chaudhuri, all these, my lord, incumbents were appointed to the post of senior superintendent from the wait list. Now, this is a procedure they follow, then they are following.
Then what is your post?
Mine is assistant registrar from above senior superintendent. That is a level 10 post and this is a level 8 post, man. The requirement is, my lord, if one has served for more than 5 years or more in the post of senior superintendent, one makes it oneself, my lord, entitled for promotion to the post of assistant registrar.
Where are the recruitment rules?
Recruitment rules, my lord. They say they have recruitment rules, my lord, but the recruitment.
These are the recruitment rules.
Yes, Lordship. All corrective recruitments.
What does it say regarding the filling up of vacancy? Is there something different from the guidelines which are given by the government of India?
Recruitment process, Lordship. But you can see page clause 6.2.3. That validity of panel oblique wait lists. The panel drawn up by Department Promotion Committee, DPC, would be valid for 1 year. The Lordship got it, bro. The date of commencement of validity of the panel shall be the approval date of competent authority of the panel forwarded by DPC. If any post falls vacant during this period, candidates will be promoted as per merit and considering the category of the vacant post. This will not be applicable in case fresh sanction of posts which takes place after the advertisement. Now here what has happened, Lordship, at the relevant time, as per our policy, the ratio was 75% to 25%. 75% to be appointed directly by direct EA, 25% by promotion. Now subsequently, Lordship, the non-teaching holds, it was revised. After a revision, they made it 50-50. They said they are complaining 75 is not reasonable. So it should be made 50-50. That was done, Lordship, subsequently. And when it was made 50-50, then automatically one post was created for promotion. It's a defined criteria and qualifications also different. I will place, Lordship, that my certificate is there.
No. Are you saying that this post which fell vacant,
Lordship,
subsequently sanctioned?
It did not fall vacant, Lordship. 4 posts are advertised, 4 persons have been selected, 4 persons are waiting list. And petitioner is also the senior superintendent. They are the people who do all the internal things. He says that I do not know that I was selected as top of waiting list.
No,
that is a different bit, Lordship. Now, subsequently, Lordship, the recruitment rules have been re-examined. And the re-examination, Lordship, recruitment rules, they made it at page 104. Lordship, kindly turn to page 103 of our 50. Lordship, kindly see. To consider and approve the recommendation of committee of revision of the existing rules, second para. The board was informed that the committee was constituted by number such and such to review the existing recruitment rules.
You're reading from?
Lordship, the item number 20. Page 103, Lordship.
Okay. Annexure 3.
Lordship.
Annexure 3.
Annexure 3, Lordship.
Yes.
Yes. To consider and approve the recommendation of the committee on revision of existing recruitment rules of non-teaching employees, restructuring their non-teaching positions and creation of a post to a certain pyramidal structure of posts across non-teaching cadres. The board was informed, this is a BOG's meeting, the board was informed that a committee was constituted by its number such and such to review the existing recruitment rules of non-teaching employees, restructuring of non-teaching positions and creation of posts to a certain pyramidal structure of posts across non-teaching cadres with such and such. Now, Lordship, kind of next page, Lordship, 104. Defined post, non-teaching post, it was revised, rules were revised. Column number 3, Lordship, clause number 3. The distribution of posts between direct recruitment and promotion in case of entry-level group A posts are inconsistent. E.g. assistant registers 75% or into 25. Assistant such and such. Last line is it. Further, the committee also noted that terms of the MHRD number such and such, dated such and such, 50% of the posts of assistant register are to be filled up by promotion. Now, this was the processing, Lordship. They suggested, committee suggested that instead of 75% into 25, it should be changed, it should be made 50-50. So that the people who are serving, they also get a scope. Now, Lordship, please. Lordship, kindly come to page 104 only, last please. The modifications, right hand side. In terms of the MSRA letter number such and such, the committee recommended to earmark 50% of the posts of assistant register are to be filled up by promotion. That was the now, Lordship, now kindly come to page 106 of this year. Column 7, Lordship. Clause 7. Selection of candidate through promotion. Lordship got it the same way. Not the first person, second person, Lordship. Selection of a candidate through promotion is being done with the following criteria. APR marks for last 5 years, actual 60%, performance in written tests 40%. The committee observed that the senior employees do not get any benefit for their long service in the institute as there is no percentage of weightage given to address employees' long service. IIT-GN and such, that means IIT-G, Non-Teaching Employees Association, also submitted a representation on this issue. Right-hand side is the changes which have been brought in. The committee recommended the following modification in the existing weightage for all promotional posts. APR, now it has been changed. It was, APR was 60% required earlier. Now for working candidate, APR marks for last 5 years, 50%. Performance written test 45% instead of 40% earlier. Length of service in a present post of the institute 5% marks. Formula of calculating marks corresponding to the weightage or length such and such, 1 mark for every completed year. The whole criteria has been changed.
So these posts,
Lordship.
were they available during that period of time or you subsequently created or?
No, Lordship, the posts are there. The question is initially 75% reserves of those posts were appointed through direct recruitment. As a result, the internal candidate, they suffer a lot. So therefore, to now, after this recruitment rules has been modified, they have made it like this, the 50% for direct recruitment, 50% will be available for the internal candidates, so they also get a chance. Entire qualifications necessary criteria has been changed. Now it is there, Lordship. Now because of this, Lordship, this is BRG's meeting, this was approved, Lordship, we kindly turn to page 109. It has been approved by the BOG. Page 109, last, Lordship, that last portion. Resolved that the recommendation of the committee as mentioned above on recruitment rules, restructuring of some non-teaching posts, steps towards paramedical structure of posts across non-teaching cadre and period of such and such is required to be we approved as per the details given above. Because this had happened, Lordship, on much after, Lordship, that this approval has been done by the BOG on 17 June 2022. Because of this revision brought into the recruitment rules, initially 25% for the internal candidate, now even 50%. As a result, automatically one post has come up for Lordship, that internal candidates. But for this one post, Lordship, as BOG approved it, automatically it stood sanctioned. So for that new advertisement is issued, and because it is not that early advertisement, and it is also applied for it, and response number 7 has been appointed. Therefore, Lordship, earlier that general notification that was given, Lordship will kindly produce that first advertisement, Lordship, it has been stated.
Petitioner also appeared for the second promotion.
I did.
He appeared for the, but he is not selected. Response number 7 has been selected. He has been appointed. That is the crux of the matter.
Why
it's through a defined advertisement, defined process, defined sanction order. When BHU had taken approved that revision, a post got sanctioned automatically. And in that post was advertised because it is not a part of the earlier post. Earlier post specifically advertised for 4 vacant posts of internal candidates and 4 waiting list candidates were selected. Within the year, if the same sanction is post vacants, then waiting list candidates will get it. But now here it is a different situation altogether. Not because that sanction was there, because the revision had taken place in between the recruitment rules. Because of the revision, internal candidates positions made 50%, one post has automatically become available for Lordship.
How many posts were there for direct recruitment?
My lord, total strength is 16, my lord. 16, my lord. Prior to the change they brought, my lord, this is not sanction, this is redistribution of posts, my lord. It was 25, 75, now it is 50, 50. 50 for internal appointment and 50 for direct recruitment. Earlier it was, my lord, 25, 75. They are trying to show that, my lord. Well, if my friend submits, my lord, but I'll reply. This is purpose to record my submission. Their own pleadings is different.
No.
Yes,
Submit Lordship, that is not a redistribution. Entire criteria has been changed. Qualifying marks and everything has been changed. And qualification has been changed. Therefore, it cannot be said that the same sanction, it is a redistributed post. And the law has been changed. Because of change of the law, new post has come. We have issued a fresh advertisement. So earlier,
in the fresh advertisement, how many posts were there?
only one.
Only one.
One was, this was accidentally has come into
Your cadre
existence.
strength is how much? 16?
16.
16.
Huh? We'll find out how many, probably
16, my lord,
posts
I
are
have
there.
stated in my pleadings, my lord, sir. They
16
do not
posts
know,
may
my
be there,
lord.
Lordship.
If
Now,
it is 16, then earlier criteria, you will have 12 posts for direct recruit.
Yes, my lord.
Lordship, 12 posts.
Which gives
And
you
4 for
posts
promotion.
promotion.
Lordship.
So these 4 posts were filled up.
Yes, my lord.
Now, if you come back to 50%, then it is 8 plus 8.
8 plus 8.
So,
But
if it is 8 posts, then 4 posts ought to have been available more.
no, because
for
people
promotion.
are already serving, you cannot throw them now because of that.
Some got promoted.
People are already serving. That's the direct recruited people are serving.
You said that because of this reorganization, 1 post fell vacant.
Lordship.
So because of the reorganization, there will be 4 posts coming to the promotees.
It should have, but not available now. Once the posts are available, we will appoint it accordingly. But at the relevant time, only one post was vacant, with others were occupied by direct recruited candidates. We cannot, because of the change of division.
So you are saying that there is a recruitment more than more than the percentage?
No, that the law has, but the rule has been changed, that now onwards.
We understand that.
50%.
If your cadre strength is 16,
Lordship.
and earlier if it is 75%, then there are
12 for direct recruitment.
12 for direct recruit. We are not concerned. There are 4 for promotees. Promotees posts were there.
Lordship.
Already 4 have been promoted.
Lordship.
Now, if you revise this rule, make it 50%, then 4 more posts are available to the promotees.
Should be
available.
In course of time, it will become available, because now these posts are occupied by the direct recruitees, unless and until they are promoted, or that vacancy will not come. We have nothing, no grudge against the petitioner, Lordship. Both are our employees, respondent number 7 and
I have
petitioner.
not done anything wrong, my lord.
Lordship.
How can I have done?
But the question is that these revision of rules you will normally do when the vacancies are available.
No, here there's been a long-standing demand by the, yes.
All right.
Lordship.
You do the recalculation, rearrangement when the vacancies are available.
No, not necessarily, Lordship. Vacancies are available, only fill up the vacancy as per the existing rules. But here there's been a long-standing demands that internal clients are suffering because of the wrong rules.
Now, if the demand is met,
Lordship.
you are meeting them only on paper, not in effect.
No, we should gradually, now the second vacancy comes.
I happen to be the second senior most, my lord. The
Lordship,
first, my
now
lord, the senior most
next
didn't
vacancy
accept the
comes,
promotion.
it will go to the promotion. But people
What
who
they
have been
are
already
substituting,
serving
my lord.
by direct recruitment, we cannot throw them out. Now they lost the vacancies either by promotion or by retirement. Then this post will go to
private respondent is senior to the petitioner. No. It is what? Selection post.
No. Selection promotion, internal candidate through selection promotion. Lordship.
No. Is it merit come seniority or seniority come merit or what? What is the criteria?
Seniority come merit, both factors are considered. Selection test is held, Lordship, taken. That shows.
So therefore it is merit come seniority.
Merit come seniority. So,
all right, you tell the court on the next date that how you have worked out and how many posts are available on the date when the decision was taken. That is the issue.
My lord, I would like to.
You are trying to project a case of malice in law.
Malice in law, also in facts, man.
Trying to say that deliberately some attempt was made to keep you out.
Exactly, man.
Right?
And what is
because this post well vacant within the
vacancy
year of the select list.
Yes.
Under the guidelines, you ought to have been
exactly
appointed or promoted.
Exactly.
But that was not done. The rules were revisited.
Yes.
And one post was
exactly. And
on the day when the rules are revisited, you must be having the number of men in position, post available men in position.
It's not the criteria, my lord. Your lordship can 16 posts is 16 posts, my lord. But now earlier, my lord, 75, 25. Now 50-50. But now 50 from when? So that total number of vacancy will be always the same, my lord. Total cadre strength will be 16, my lord.
We know that. That is why we are asked. We want to know, supposing a man who's working in the post and he's got 10 years of service available.
My lord.
It makes no sense to revisit the rules today.
So that's outstanding demand, my lord. That point of time, one.
We understand that. Meeting a demand.
My lord.
Meeting a demand will mean that you are effectively trying to resolve the dispute or the demand. Hypothetically, let us say you segregate the posts, and according to these rules, revised rules, 4 posts are required to be given. According to you, at that relevant point in time, only 1 post was available. So, from the records, you should satisfy the court that these 3 posts were not available immediately, but are likely to be available within a short time. Otherwise, it does not make any sense that these 3 posts will become vacant after 3 years or 4 years or 5 years. And you have already revised the rule saying that these posts are meant for promotees. Unless you say that all these promotees in terms of seniorities would be available to claim these promotions beyond this period, up till the period when these posts held by the direct recruits will fall vacant. This is
This is
an exercise that the IIT authorities will have to do. Otherwise, the revisitation of the rules makes no sense.
Rules that will remain till Lordship. The rules has to be changed, not because of that Lordship. I understand your Lordship.
The purpose of changing of rules is to make it applicable. But in practice, you can't make it applicable because the posts are not vacant. So the next question would be, when are the posts likely to be vacant? So
That
the
I,
rules
that I'll
can be
inform
applied.
your Lordship in the next thing, Lordship. That I'll take the exact position and inform the Honorable Court.
But their records are not there.
That is the problem, Lordship. That's why.
My lord,
How is
records,
that
my
happen,
lord.
Lordship, that this Honorable Court made it recorded that documents have been
Those records
submitted?
will not help, my lord. Those records are, this was
the
precisely
honorable
the
court to
reason my lord,
decide.
why the records relating to the creation of post was called for a redistribution, my lord. The vacancy position. They send the selection records, man. That is of no help.
I heard Mr. B.D. Goswami, learned counsel for the petitioner, Mr. R.P. Kakoti, learned senior counsel appearing for the IIT, Mr. T.J. Mohanto, learned senior counsel appearing assisted by M.S.P. Bhattacharya, appearing for respondent number 7. The pursuant to the earlier order dated pursuant to the order dated 18/9/2025, whereby the registry was directed to inquire into the matter and trace out the records stated to have been submitted to the court when the matter was last heard on 19/3/2024, and which is reflected in the order dated 19/3/2024, and which the respondents IIT submit are not available with them, as the same were handed over to the court on the same last date on 19/3/2024. So for the pursuant to the same
records
order passed, the registry has inquired into the matter and where is the report? It's here. And by office note dated 15/10/2025. The following report was laid before the court. It will extractory by the registrar judicial. This report is available in the note sheets pertaining to WPC 3423 of 2023. In view of the reports submitted before the court, the learned senior counsel appearing for the IIT submits that a renewed effort would be put in to trace out the records.
Records are not with us, we submitted already.
Then what do you intend to do?
Not
Reconstruct the.
No, we reconstruct the records.
We'll attempt to reconstruct the records and place the same before the court.
Xerox copies. No Xerox copies.
The registry will also continue to make attempts to trace out the records stated to have been submitted to the court, before the court, when the matter was heard by coordinate bench on. Which date was it?
24.
19/3/2024. Stop. Correct. The counsel for the petitioner submits that the grievance of the petitioner is that in spite of he being eligible for promotion to the next higher post of assistant registrar in the IIT Guwahati, and having been placed at
The top of the waiting
top
list.
of the waiting list, the authorities of the IIT Guwahati did not consider his name for promotion to a vacant post, which came to be available during the currency of the select list and the wait list
My lord,
for the year.
currency of the select list is all right, that by that, my lord, 18 to more than that, it is the vacancy year, it's called vacancy year,
During the
31,
vacancy year, which year?
22, my lord.
2022.
Yes.
Stop. The counsel for the petitioner submits that the with disregard to the Government of India guidelines,
Yes, my lord. DOPT guideline,
DOPT guidelines
Department of
dated,
Personal Training.
dated
My lord, this is not like that, my lord, these are the
DOPT guidelines, which are
DOPT
available as a part of the pleadings. The vacancy was not filled up by the persons, by the names which are available in the wait list.
Yes, ma'am.
And the petitioner being at the top of the wait list, he ought to have been selected and promoted to the post in which the private respondent number 8 has subsequently been selected. So,
7.
I will respond on 7.
7. The further grievance of the petitioner is that this promotion to the private respondent 7 was effected by the IIT authorities by reorganizing / revisiting the rules and thereby projecting that the criteria for promotion has been altered, and therefore persons available in the select list, wait list in the earlier selection process are not eligible for being considered to be appointed. Stop.
And also
The counsel for the petitioner also submits that the fact that the petitioner's name was reflected in the top of the wait list was not published, and as a consequence thereof, the petitioner was not aware that his name appeared in the top of the wait list for the selection to be undertaken for the vacancy year 2022. And as a consequence thereof, the petitioner had presented himself for selection to the post of, to the vacant post in the subsequent selection process. Para. Per contra, Mr. R.P. Kakoti, learned senior counsel, assisted by Mr. A.B. Day, appearing for the IIT, submits that the interpretation sought to be projected by the writ petitioner is not correct. So there was a long-standing demand of the employees of the IIT Guwahati,
Non-teaching, non-teaching employees.
non-teaching employees of the IIT Guwahati, that their promotional quota for promotion to the next higher posts should be increased from 25% to 50%. So taking into consideration these long-standing demands, the competent authority in the IIT Guwahati undertook the process to revisit the rules and rework out the percentage earmarked for promotion and appointment through direct recruitment. So it is submitted that after the rules have been revisited and the percentage of promotion having been increased from 25% to 50% per month, a new process for promotion was required to be undertaken, as this post, which was filled up by the respondent number 8, fell within the quota, fell within the quota of 50% allotted to the promotees, and which post earlier was within the quota of the direct recruitments when the quota was earmarked at 75% for direct recruitments. So it is submitted that as and when further vacant posts are available, the eligible non-teaching staff of IIT Guwahati would be considered for promotion to such posts in terms of the quota prescribed under these rules, recruitment rules. So that in order to decide the matter, in order to decide the lists between the court, it would be necessary for the respondents to place before the court the relevant materials to show that pursuant to the increase in the quota for promotion at the relevant point in time, only the post which was subsequently filled up by the respondent number 7 was available and no other posts are available. So the learned counsel, senior counsel for the IIT Guwahati therefore submits that the sufficient time be granted to reconstruct the records, to have these information sought for by the court to be placed before the court. Mr. T.J. Monto, senior counsel, assisted by Ms. So-and-so, also submits that selection process undertaken by which the petition respondent 7 who promoted was as per the procedure prescribed, and the petitioner having submitted to the said selection and participated was not selected on merits, and therefore his claim that this post ought to have been filled up as per the earlier rules cannot be accepted, as the vacancies available are required to be filled up. Vacancies available pursuant to the rules being altered are required to be filled up by the subsequent rules, laying down the proportionate quotas between the direct recruit and
by submission, it is a face sanction portion.
it is further submitted by the learned counsel for the respondent number 7 that this post is a fresh sanction post. By the sanction, by the order, do you have an order?
My lord,
BOG's decision.
as per the board decision, my lord, because it was afterward, because in the benefit which is yet been taken, that is very clearly mentioned, it is not applicable. Waiting list is not applicable to the, my lord, face sanction postman.
Fresh sanction post. So he therefore submits that the wait list, candidates from the wait list will have no claim in respect of freshly sanctioned posts.
Is sanction after the board decision 17/6/2020.
Stop, the post was sanctioned after the decision of the BOD on
17/6/2020.
17/6/2022 is the date of sanction or the
That
date of
the board has taken a decision.
the sanction pursuant to the decision of the BOD held on 17/6/2022.
BOG
BOG, Board of Governors, 17/6/2020.
2020.
Accordingly, let the council appearing for the IIT Guwahati place before the court the relevant materials as directed.
My lord, may I just, records relating to the sanction of the post.
We are just giving them, they are aware of what records are to be given.
Yeah.
We need not specify. We only say the relevant records.
That's
Be placed before the court on the next date fixed on
after 20th of January, Lordship, was period.
22nd January.
Lordship.
Oh, 22nd,
Just like that.
22nd January.
My lord, may I pray for a placement at the top of the list, my lord?
You mentioned
It's
it,
been pending for a long
you
time.
mentioned it before the court on the day. You are entitled to make a mention for upgrading if required.
Right.
List accordingly.
Keep the right.
That port will, the last matter, the port will.
In item number 26, your lordship, we would like to fix some more time because the records we have received is not complete. So for further 10 days time may be granted. My lord, records of disciplinary proceeding was called for by last occasion.
Mr. D. Bora appearing for the respondent state renews his prayer for further time to place before the court the relevant records of the disciplinary proceedings. Mr. A. Paul, learned counsel appearing for the petitioner submits that the opportunities were earlier granted for placing the records by the respondents. However, the same have not been placed before the court. Considering the fact that the matter pertains to dismissal, termination from service.
Dismissal from service.
Dismissal from service. We direct the respondents to place these records before the court. On 27th of, on 22nd of January.
22nd.
22nd of January.
Keep left.
27.
Your lordship, the matter as such relates to downgrading of APR. The matter relates to downgrading of APR, APAR, ACR, APAR. Now it's called APAR, Annual Performance Assessment Review. It will take some time, your lordship. Your lordship may take it after Bihu vacations.
On the request made by the counsel for the petitioner, matter stands deferred to be listed again on